Yes.
She may be permitted to mention.
Admission of what appeal? First appeal, no admission is required. It's automatic admission. Yes.
She may be permitted to mention a matter in which your lordship had past direction of paper book, your lordship. Unfortunately, due to some personal difficulties, your lordship, we have filed
What do you want to know?
requisites for a paper book and special.
You want an acceptance of that?
It has to be regularized, your lordship, because it's filed.
You mentioned.
Your lordship.
Yes.
Much obliged.
Yes.
Decree of eviction passed on the chapter 13A. Any day it will be executed, man.
No, this is an application.
This is, yes, application, stay application.
Yes, yes, absolutely.
But this, let's say, Wednesday, I believe lordship takes up on original side of the Wednesday.
Yes.
One matter also first in order file the paper book upon the appellant. The appellant did not file the paper book.
Original side, দিয়ে দিও, ওকে দিয়ে দাও না। কি করছো?
In spite of direction, no paper book has yet in service. My lord, we are suffering as the respondent.
What are you wanting now?
My lord, let it be appear 2 events.
For
passing the necessary order.
what order?
Necessary order for paper book direction was given.
Yes, so that
has not been done. After the if not paper book is given, the order passed upon the respondent to file the paper book, so the matter can be disposed of.
You are the respondent?
I am the respondent.
Yes. To mention.
Kindly, my lord, to mention this matter. This pertains to the list and determination. Honorable Justice Showman said, my lord, the interim order, my lord, is only till today. The nature of the interim order, my lord, there was
Justice Sen will be sitting tomorrow, probably tomorrow or day after.
Still possibly this week or possibly my lord, Justice Sen is
No. Justice Sen's Andaman determination will be over today. He's not there for 2 weeks.
because the interim order, my lord, is still today. My lord, may I indicate what has happened?
Today, in any event, we cannot extend.
Can be, my lord, directed to
Mention before Justice Sen. Yes. Justice Sen returns tomorrow. Up to today.
Next week, I thought.
Justice Sen's bench is till next week.
Next week. Oh, sorry. Then hand over this.
This is the order.
Whenever the file comes, we'll put it as to for extension.
So the interim order is till today, and
We'll extend it. We just inform the other side. Original side, don't give it.
the other side is here. Niharika Singh is here.
Yes. So Wednesday it appears. Original side day. Yes.
And my lord, may it be understood that they will not, because if the stay goes, they can transfer.
We cannot say anything on that, Mr. Mitra, before it appears in the list. What is this? An application?
It was to be brought before at the children park, but it is not done, and he has been removed to Bombay, where father is employed. My lord may remember that my lord take interview of that.
No, so what are you wanting now? It will be
It appears under the heading to be mentioned, so that necessary order may be made, my lord.
what necessary order? Then you have to file an application.
Because
We dispose of an application already. We'll give a notice to the other side. It will appear as to be mentioned. Yes. Application handover. This is an application. If it's an application, we are including in the list. You are now mentioning an application to be included in the list. Please hand over the slip, ma'am. Yes. Hand over.
May I, my lord's kind leave, my lord, to mention item number 118. This matter, lordship will recall, the lordship, while admitting the appeal, my lord, directed me that it will appear in the list. You wait for 2 weeks or 3 weeks, then if possible, you kindly mention, because this is the matter where my lord,
We cannot upgrade.
possession was forcefully.
Understood, but no upgradation. You can file an application, but no upgradation. Yes.
Well, this is an application under
Well,
section 5 in
application
connection with a order 41 matter.
Which lordship's
Any
leave, my lord, remember.
Application.
No. Just praying for an accommodation. My lord had fixed this matter on Wednesday. It is that matter, my lord, Mr. Arindam Mitra was arguing. And Mr. Shoposhaji Chaudhary, my learned leader,
Yes.
was replying. My lord, he had some difficulty on Wednesday.
Let it appear in the list. It has been directed to appear in open court. It will have to appear in the list.
We
On
will-
that date, ask
My
for
lord,
it.
just praying for accommodation so that it stands over till Monday, my lord.
No, you have to pray for that extension when it appears in the list.
We will.
Yes.
I'm grateful.
The application.
Pardon? Hearing, we are not taking Mr. Dhol.
Application for
Application handle.
lordship order for
Order for 20 minutes.
Hello, I'm praying for upgradation for my, it's item number 125.
Upgradation, we are flatly refusing. Sorry, ma'am. Yes.
This is an application, my lord.
Yes. Call on the list.
order 41 will.
Yes.
I'll just mention one matter, my lord.
Yes.
Question one matter, my lord.
Application.
No, my lord, for preparing the paper book, my lord. My lord, old matter, my lord.
Just write to be mentioned there and hand it over.
Already, my lord, there is a order, my lord. Let informal paper will be prepared by the registry with a period of 4 weeks from the date of.
Why are you moving the matter at this point of time? Ask, just write to be mentioned there. Yes, call on the list.
আমি ডেটটা দিলাম।
Despite repeated communications, comma, no report has yet come from the learned Chief Judge, City Civil Court at Calcutta. Full stop. As a last chance to the learned learned Chief Judge, comma, City Civil Court at Calcutta, comma, the matter is postponed till March 24, 2025, when it will be listed under the same heading. Full stop. Next para. In the event no such report is filed before is placed before this court by the learned Chief Judge, City Civil Court at Calcutta on the next by the next returnable date, comma, appropriate orders shall be passed by this court. Full stop. Let this order be communicated immediately to the learned Chief Judge, City Civil Court at Calcutta. এটা অফিসে নামিয়ে দেবেন, চিফ জাজকে যেন আজকেই কমিউনিকেট করা হয়।
But I appear for the appellant. These are those matters, my lord. On the last occasion, your lordship was kind enough to, my lord, grant me leave to direct me, my lord, to have a chart prepared with regard to the applications.
Please, for the other side.
But Mr. Dilip Kumar Maiti was appearing on the every occasion. But I have, pursuant to your lordship's direction, I have served the copies which was unserved, as well as the, my lord, chart that I have prepared. The chart, my lord, I found, my lord, since there are 20 applications pertaining to respondent number 2 to 9 substitution, as well as abatement, setting aside of abatement, as well as section 5. But I found it, my lord, that preparing a chart in one singular paper would be a certain difficulty.
Whatever.
So I had prepared, my lord, singular with regard to the names and the respondent numbers. My lord,
No, the chart has to be the section 5,
yes.
corresponding abatement, setting aside abatement, and corresponding substitution application. That has to be there.
My lord, I have subject to your
You have filed 3 sets of applications:
Yes.
section 5, setting aside abatement, and substitution.
substitutions.
So for
As well-
X, for deceased X,
Yes.
there has to be in the same column, in the same row, the numbers have to be given. The list has to be like this: substitution application, setting aside abatement application, section 5 application. For each person, the chart has to contain those numbers.
In columns, probably.
Yes, rows.
My lord, I have,
That was what we asked for.
my lord, I had,
We have to have the corresponding. We will just take up the section 5, corresponding setting aside, and corresponding substitution, and dispose of one at one go. Each of those sets.
my lord, I was probably mistaken, my lord. I have prepared individual charts, my lord.
We are
for
not
all-
interested in individual charts.
My lord, I was.
We just require a paper where we will give the numbers. Suppose there are 18. For 6 set of deceased persons, 3 application each. One set section 5, one setting aside abatement, one substitution.
Right.
Put for one person, put it on in a single row. Come back next Monday, Deva, or
My
whenever
lord,
you
my
can.
lord, tomorrow, my lord, I shall.
On the prayer of the appellant, the matter is adjourned till tomorrow.
Day after tomorrow, my lord.
Tomorrow, come back. Why? What is the time? Yes.
Day after if they do not.
Next. Please give your names. Yes.
Item number 4, my lord, I am appearing on behalf of the petitioner. Lord, I'll be praying that your
Or I
lordship
felt a record. Yes, Mr. Dotto.
will be able to be kind
Please use
enough.
the microphone. We can.
Lord, your lordship will be kind enough to take up the matter tomorrow or day after, because
Why?
I have the affidavit of service, but it has not yet been affirmed, my lord. My lord.
I'll give you leave. The service has been affected.
Yeah, yes, my lord. Almost affected, 2 has returned.
We will come back tomorrow. On the prayer of the appellant, the matter is adjourned till tomorrow.
Grateful, Lordship.
Application. For the bill, sir. I have again served, but they have reached, have not, could not produce the affidavit service. But delay of, condonation of delay of 8 years, my lord. That is the
Delay in filing what?
filing the appeal, my lord, first appeal.
Section 5 টা কোথায়?
Condonation of delay.
There is a substitution application we file. Oh, acha, there is a delay application. Substitution
And
has been-
constitution, condonation of delay. My lord.
condonation of delay in filing the appeal, but somebody has died in the meantime.
Died in the meantime.
Substitution application has been filed in time.
Filed, no, 8
We
years.
cannot pass an order in the name of a deceased person. Either we allow or dismiss. We have to take up the substitution application first.
No, no, first condonation of delay. Take up the matter, condonation of delay. And
Can you take
thereafter,
up a condonation application which is in the name of a dead person? Can any order be passed in the name of a dead person?
subsequent they have expired. After filing,
As of today, those persons, some of those persons named in the Section 5 application are dead. How can you pass even a single order in the past in the name of a single dead person? What are you submitting? This is basic law. You are practicing for so long.
but
Can we pass a single order in a Section 5 application in the name of a dead person after knowing that that person is dead? We have to take up the substitution application first.
substitution application may be taken first.
What is the delay in filing the substitution?
Substitution we need time.
That is what we asked you. Then what is the Can 2 for? Can 2 is the Section 5 regarding the main appeal.
Main appeal.
Acha, very well. Substitution, who has died?
Only one, opposite party one, and that is the appellant, the defendant. Nurul Islam is the died expert.
Only one respondent, he has
One.
died. You have to serve. I will allow this and direct you to serve copies of the Section 5 on
I have substitution also served, but unless and also have served.
Section 5 you have served on the heirs of the deceased.
Yeah, this is
Where is the affidavit of service?
already I have filed, but only one last return to one return, one service return. So again I have served.
No, you have served in respect of the respondent only, the original respondent.
Original respondent died. They have to substitute in the
On this proposed substituted heirs also you have served.
yes.
That restoration application that was allowed previously. There was a restoration application.
Restoration was, this application was dismissed for default.
That has been allowed.
Yes,
It
yeah.
has been restored.
Allowed.
We can't find any affidavit. Yes, there is one affidavit of service. Affidavit of service, there is no track report.
Another one,
There is no track report.
another.
And you have served only on 2. Whereas in your application, you have sought for substitution of 4 persons.
4%. I have served 4%.
The postal track reports, the postal receipts, and your forwarding letters names only 2.
Thereafter, want the 2 return. Again, my lord directed to serve further.
You have to serve on all. We have only one affidavit of service on record. Anyway, Can 1 of 2021 is an application for substitution of the. You said it is in time, it is not in time.
Substitution.
Died on, yes. করোনা পিরিয়ড হলো দেখে নিতে হবে এক্সাক্ট টাইমটা হচ্ছে কি কবে ফাইল করেছে দেখে নিন
During the lockdown period.
yes yes then it is not that it is in time, it is beyond time, but due to the pandemic relaxations you are asking for. The present application Can 1 of 2021 is an application for substitution of the heirs and legal representatives of the deceased sole respondent Nurul Islam. Full stop. We find from the averments made in the application that the entire period of delay in filing the application is covered by the pandemic relaxations granted by several successive orders of the Supreme Court. Full stop. Hence, the application is treated to be in time. Full stop. Accordingly, can 1 of 2021 is allowed, thereby directing substitution of the heirs and legal representatives of the deceased sole respondent Nurul Islam, as indicated in the cause title of the present application and paragraph number 5 of the application. Full stop. Next para. Necessary consequential corrections shall be incorporated in the cause titles of the Memorandum of Appeal as well as Can 2 of 2020. In the Memorandum of the Appeal by the learned advocate on record for the appellants during the course of the day. Please correct the memo accordingly. Push up next para. We find from the affidavit of service which is on record that only the postal receipts regarding service of the applications on 2 of the substituted respondents has been annexed thereto. Thus, we are not satisfied on the satisfied regarding the service of the application for condonation of delay on all the substituted respondents. Accordingly, the appellants shall serve copies of Can 2 of 2023 on all the substituted respondents, indicating that Can 2 of 2023 shall be listed in the listed on April 8, 2025 under the same heading. An affidavit of service in that regard shall be filed on the returnable date. Can 3 you say has been allowed?
Allowed.
বলছি যখন দেখেন দেখে নিয়ে When was it restored?
Restored.
What is the date of that order? You must have your endorsement in your brief. Yes. Next one. No, absolutely.
The present appellants are the plaintiffs in the partition suit.
Right.
Partition suit dismissed on the ground that other co-sharer have not been included as a party in the suit. We have challenged this, filed this memorandum of appeal within time. There is no section 5. Now, Lordship, I filed an 2019 application. That is an application for stay on the ground that when the suit has been dismissed, the defendants file an application before the SDO, concerned subdivisional officer, and subdivisional officer, without having any jurisdiction, kindly come page 17.
Have you checked out the defects in the appeal?
So, for defect, Lordship, the one of the appellant expired, I have filed an application for Lordship substitution.
Appellant number 5 and 6 does not tally with the plaintiff numbers 2 Gho and Wo. Who are the appellant numbers 5 and 6? 5 and 6 are
appellant number
Soujira Bibi.
Soujira Bibi alias
Abul Bakir.
Soujara Bibi.
Let us see the decree. ঘ কোথেকে পেল? তুই তো কোনো ঘ নেই। এটা তো ফার্স্ট অ্যাপ্লিকেশন। ঘ হচ্ছে লক্ষ্মীমন বিবি আর হচ্ছে মৌজারা বিবি।
No, this is Moujara.
And Gho is Lokhiman Bibi. Lokhiman Bibi name is correct.
Yes.
Report is wrong on
It
that.
is written in the decree Moujera. But Lordship, her proper name is Soujara.
No, then it does not tally with the trial court decree was not never corrected. So the names do not tally then. You had to make an application in the court below then for correction of the decree. And what about this Abdul Bakir, alias Bakir Sheikh? We find only one Abdul Basir.
Abdul Basir.
Basir, but you have named him in the memorandum as Abdul Bakir. It's a different person.
Yes, Abdul Basir. Abdul Bakir will be Abdul Basir. It is
Yes.
written wrong in the as per the voter card and Lordship D of the
No,
concern.
but we cannot take cognizance of this because it never corrected the trial court decree. Correct the memorandum, putting in an alias and putting those names also. But do that, unless you do that, we cannot take up the appeal. So that is the first defect. Second defect is, you should have checked up, Mr. Mukherjee. Defendant number 2 of the court below died after pronouncement of the judgment. Legal heirs were brought in as.
I have filed an
For this, you have filed an application. Leave. And the other one, respondent 4 to 7, does not find place in the certified copy of the decree. What about that? Respondent 4 to 7.
4 to 7.
They are not there in the decree.
Wife of Kader Sheikh.
What about them? How have you included them?
Yusuf is there, Lordship. Who? Yusuf.
4 to 7. 4 to 7. 4 to 7, it is, the report is 4 to 7 of your memorandum are not there in the trial court decree. Respondent was 4 to 7. This Nurjan, Nokleja, Sirivan Bibi, Horida Bibi, they are not there in the trial court decree.
There is no, their name is not here.
Then it's time barred against these people.
So
many, plenty of mistakes, Mr. Mukherjee.
Lordship, Imam Sheikh is respondent
We
number
cannot
9.
sit here and waste time over the day. Please check up. There appears to be several defects in the memorandum of appeal. Full stop. The learned advocate on record for the appellant is granted leave to carry out the necessary corrections to the memorandum of appeal accordingly. Full stop. The matter be placed in during the course of the day. Full stop. The matter be placed in the list tomorrow. Whatever correction you can, you do. Otherwise, I will take it up tomorrow. You just check up in the meantime how those names came in. Go through the records and find out how 4 to 7 came in. If you have to file an application, pray for that tomorrow, we'll grant you leave. One application regarding that leave, we understand. But regarding the others, 4 to 7, they're not there in the trial court decree. And regarding that alias, put in alias or whatever, we need not advise you. Regarding the 2 names which are not tallying, do that.
So leave be granted.
We have granted leave. That is the first sentence of our order. Whatever you can do, do. Whatever you can't, come back tomorrow and we'll first check up the files. Yes. Next.
I'm for the appellant petitioner. See that initially the matter was dismissed on 20th September 23.
Right.
But recently I have got the information that the respondent has also died. So it is required for their substitution.
So their substitution has to be allowed first.
Yes, Lordship.
Is that within time? If not, then Learned Counsel for the appellant submits that recently he has come to know that the respondent has died in the meantime, full stop. Accordingly, on the prayer of the appellant, leave is granted to the appellant to take appropriate steps in that regard, full stop. Let the matter go out of the list for the present with liberty to the appellant to mention all applications, as and when filed, for inclusion in the list. Please file all the applications, missing applications, and mention together. We'll take.
একটা দিয়ে দাও সব পেইটে ওদের দুটো আছে না না দুটো নেই একটাই আছে আমাদের একটা ছিল মানে it is bad মানে we made mistake মানে we have
that acha right
made a correction মানে
right
that effect regarding the can number 2
These are the total corrections.
Yes,
Regarding can 5, there is no mistake.
there is no mistake. Only can 2 there is mistake.
Can
And
3 also. Can 3.
Can 3
Can
also.
4 also.
Yes.
We'll right now correct the order. We'll pass on. In the order dated March 10, 2025, comma, certain mistakes inadvertently cropped up due to a communication gap between the court and learned counsel. Full stop. Next para. Full stop. Such mistakes are as follows: colon diye, niche Roman 1. In paragraph number 1 of the order, in connection with Can 4 of 2020, comma, in the third line, comma, the expression double inverted plaintiffs, double inverted close, shall be replaced by double inverted defendant number 6, full stop, Roman 2. In paragraph number 3, comma, the expression double inverted plaintiffs shall be replaced by double inverted defendant. Full stop. Next Roman. In the 5th paragraph of the said order, comma, in respect of Can 3 of 2020, comma, in the third line, comma, the term plaintiff, term plaintiff, double inverted, term plaintiff shall be replaced by defendant number 1. Full stop. Next Roman. In paragraph 6, comma, in the 4th line, comma, the expression plaintiffs shall be replaced by defendant number 1. Full stop. Next para. Rex Roman. In respect of Can 2 of 2020, comma, in paragraph number 8 of the order, comma, the expression double inverted plaintiff shall be replaced by defendant number 3. Full stop. The above orders, the above errors be deemed to stand corrected in the order dated March 10, 2025. Accordingly, full stop. Let this order be deemed to be incorporated in the order dated March 10, 2025. Whenever you apply for certified copy of this order, 10th March order also applies certified.
Can 2. Your lordship will direct them. We are the defendants. They have failed to make substitution in spite of notice.
With regard to that, your lordship, because of our mistake, your lordship directed Mr. Ghosh's client to file a supplementary affidavit. Now, it appears, if your lordship kindly see Can 2, page 23.
No, which paragraph should we? Where did you direct?
It has to be
appellants are granted leave to file a supplementary affidavit in paragraph 11.
Yes, we the plaintiff did not file the substitution application, although the defendant, one of the defendant expired in 2017. It is because of our mistake, your lordship directed Mr. Ghosh's client to file supplementary affidavit. It should be corrected because the plaintiffs were at fault. Now, so far as that question is concerned, kindly come to page 23 of the Can 2.
Yes.
The information about the death of Saidul Haq, it was reported by the defendant number 5 on 27th November 2019. If you kindly see the top, there is the filed on 27th. No, the judgment was delivered on 28th November 2019. So, one day before the delivery of judgment, this intimation was given by the defendant number 5 to the court. When the
before that, Lord, amendment took place.
It said suit for partition, order 22 rule 10 will apply. So, subject to your lordship's kind correction, if the application is allowed, it will inure to the benefit of the trial stages.
So then only Can 2 has to be allowed.
Can 2.
The other applications have been.
Yes. Other application has been disposed of. Only that correction is there, Can 2 to be. Can 2 to be allowed,
Can 2 is by you.
No, Can 2, all the applications by my
Mr.
Application for addition.
Can 2 is for addition of party.
Addition of
party because he died. long before passing of the preliminary degree on 9th March 2017. Preliminary degree passed was on my lord 18th November
28th
2019.
November, 28th November
No,
2019.
you are the defendant.
Yeah,
Dependent.
And the deceased person is
Dependent.
Dependent.
Number 10.
so therefore
Because
they
dependent
failed
number-
to file this substitution application.
Yes.
And this is against a preliminary degree.
Yes. my lord.
Can 2 is for addition of the years.
Addition of the years of defendant number 3, my lord, who expired on 2017, but it was reported to the learned trial judge one day before the delivery of judgment. The judgment was delivered on 28th November 2019.
We are allowing can 2. Next para চলে যাও যেটা বললাম তারপরে it is pointed out by learned counsel, learned senior counsel for the parties that the death of the defendant number 3, defendant number 3,
My lord.
defendant number 3 in the suit from which the present appeal arises was informed to the trial court only on November 27, 2019, that is 1 day before passing of the final judgment, 1 day before passing of the impugned judgment and preliminary decree. Push up next para. As such, the plaintiff was not in a position to file any application for substitution. Full stop. Thus, although we had directed in the order dated March 10, 2025, that the appellants are to file a supplementary affidavit explaining the delay, in view of such delay having been explained in the above manner, and also in view of the settled proposition of law that in a partition suit, the cause of action is deemed to be continuing, and as such, the principles of Rule 10 and Rule 10 of Order 22, as well as Order 1, Rule 10 of the Code of Civil Procedure are applicable, can 2 of 2020 is allowed, thereby
Paragraph 6, my lord.
thereby directing the heirs and legal representatives of the deceased appellant number 3, particulars of whom have been given in paragraph number 6 of the application, to be substituted in place and stead of the said deceased. Full stop. The necessary consequential corrections shall be. Did you direct the office to carry out the corrections?
No, it has been already.
It has already been, my lord, incorporated in the
in the
cost
copy.
package.
The memo.
In the memo.
Memo.
Acha.
In all the lord applications.
Next para kore daw. Since the necessary amendments in that regard have already been incorporated in the memorandum of appeal, no further steps need be taken. We have disposed of can 2.
No, can 1.
Can 1 what is that?
Usual order, lord, preliminary has been passed, your lordship can.
So that is the stipulation. Injunction you have asked for. Can 1 is for-
Injunction, lord, they have filed an application for injunction.
Oh,
That has
can
been
1
disposed.
is application for injunction. Prayer is also injunction. And there is a humility in that also. Humbly you have prayed for injunction. Not a single line regarding stay.
Usual order, your lordship.
Oh, restraining them from proceeding with the final degree proceeding.
Yes.
Yes.
That's very good. Can 1 of 2020 is an application for injunction restraining the plaintiff's respondents from proceeding with the final degree proceedings. Push up. Since the appeal has been preferred against a preliminary degree of partition, can 1 of 2020 is disposed of by directing the learned trial judge to continue with the final degree proceedings, but desist from drawing up any final degree without the prior leave of this court, till disposal of the appeal. Push up. Paper book directions were given, Mr. Ghosh?
No.
You are directing?
Give it. I'll kindly give the.
Well, the appellant shall prepare and file the requisite. You are appearing for all the respondents? No.
No, my lord, I am appearing for, my lord, 1 to 5 and 8 to 15.
In view of appearance of respondent numbers 1 to 5 and 8 to 15, through their learned advocate, comma, service of notice of appeal on the said respondents is dispensed with, full stop. The appellants shall put in requisites for service of notice of appeal on the remaining respondents within a week from date.
No,
Full stop.
no.
Next para.
Plaintiff.
The trial court records shall be brought by special messenger, comma, retaining a skeletal record for the purpose of proceeding with the final degree proceedings, comma, by special messenger at the cost of the appellant, full stop. Such cost shall also be deposited within a week from date, full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Lord, so far the defendants number 10 to 60
Defendants, we don't know. The respondents, we are only concerned.
respondents, but they were not ex parte. They didn't contest.
Partition suit, serve on. No, notice on. Yes. 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 Yes, Mr. Shaw, what is the matter? Mr. Chatterjee for the other side?
Yes.
Yes. Yes, Mr. Shaw, what is the matter? 2 applications. All served.
My lord, my.
You are appealing for all? Mr. Chatterjee? Oh, only one.
May I request your lordship to kindly come to the order dated
Please take the microphone a bit up. Yes. Order dated
12th February 2020.
12 February, yes.
2020. This is the observation made by your lordships when the matter was heard. But since my learned friend had raised objection against the CAN 4, they have filed written objection CAN 4. I am filing affidavit in reply against the CAN 4. Copy has already been served.
File it, yes. 1, 2, 3, 4, all are pending.
Yes, ma'am. One was application for stay filed by the predecessors in interest. The first executor who has already expired.
This
After
appeal
that,
arises out of what?
this is arising out of an order passed by the learned Chief Judge City Civil Court allowing the succession certificate during the pendency of my application that I prayed that I want to intervene in this application, in this proceeding, and there is a will which has been filed for probate. Court asked me to produce that document. A date was fixed, but they have preponed the date and order was passed.
So one is
Stay.
for leave to prefer appeal.
Yes, that has now become infructuous because that was filed by the first executor, Brujendranath Mandal, who has already expired. And number 1, GA is for stay. And number GA2 is leave to appeal. Now I have filed 2 applications, GA3 for substitution when the objection was raised by
So
Malala.
this CAN 7614, what is the present number?
761, that is CAN 2.
এগুলোর উপরে কারেন্ট নাম্বার গুলো লিখে দেন না কেন? উপরে লিখে দিচ্ছি লিখছি। So CAN 2 has become infructuous. You can record
Yes.
that first.
Yes, yes.
Mr. Chatterjee, no difficulty. CAN 2 infructuous. Brojendranath petition has died.
Yes, my lord, the petitioner has died, but I think, my lord, your lordship would need to probably, my lord, look at the entire thing together.
No, but this application cannot
No.
survive. So I will just dismiss it as infructuous. He must have another application for leave to prefer appeal.
Yes, my lord. Yes.
So we'll
That is
decide
CAN
that.
4.
Yes. CAN 2 of 2018 within bracket old number CAN 7614 of 2018 has been rendered infructuous due to the demise of the petitioner therein. Full stop. Accordingly, CAN 2 of 2018 is dismissed as infructuous. Full stop. Yes. Which application should you take up? Stay last. Then CAN 3 is one and CAN 4.
4.
So CAN 4 you should take up first. Substitution.
Yes.
Lord, there is a
Substitution.
problem of limitation here.
No, substitution
Cannot happen.
no, there cannot be any substitution.
And also, my lord, with respect to leave to appeal, there is a problem of limitation.
No, appeal has been filed by
the
them.
the other one who is now passed away.
Order 20 Rule 10 principle.
No, Order 20 Rule 10 doesn't come in here. He is not coming in place of, he's not the legal representative, my lord, of the other, my lord, executor.
two executors, not order 20 rule 10. It hasn't vested in him. And they were jointly together. So he is now filing a fresh appeal. Not he can't proceed with the other appeal filed, my lord, by the other executor. It's a point your lordship decides. I've got.
Can 3 and 4 are similar?
Yes. So
He
he
is
has to file an
substitution. There
application.
can 3 will reject first. We'll say no question of substitution arises. We'll take up.
So we have filed, my lord, leave to appeal, my lord.
4 will
Then
take
he
up.
has to say leave to appeal.
Let us
my lord.
eliminate. By the process of elimination, we'll proceed. Next para হচ্ছে can 3 of 2024 is an application for substitution of the name of one Brajendranath Mondal, comma, since deceased, comma, in his capacity as an executor to a purported will, on the strength of which the said Brajendranath Mondal claimed to prefer the appeal. Push up next para. In brief, comma, the present appeal has been preferred against the grant of a succession certificate in favor of the respondent. Full stop. However, comma, in view of the executor, in view of one of the executors of the purported will being Brajendranath Mondal, comma, having already met his demise, comma, his heirs cannot be included, comma, since the principle of Order 22 Rule 9 does not come into play. Full stop. Next para. Hence, comma, on the demise of Brajendranath Mondal, comma, there cannot be any substitution as such. Full stop. Accordingly, can 3 of 2024 is dismissed as not maintainable. So next para, can 4 of 2025 is now taken up for hearing.
No,
We'll
look,
just give
once this order comes into play, the appeal is not there in the IOP.
no. Can 4 will take up.
Can 4, my lord, is in this appeal.
Yes.
So this appeal cannot be taken forward.
No, if you grant him the leave, then it.
This appeal has gone, my lord, with the appellant going.
Not
He can
necessary.
file a fresh appeal with a leave to appeal. I can understand.
The first executor died
I
in
can
the
understand.
month of April
Not this appeal.
2024. And that
Then there will
application
be
was filed
It's
with the
arguable. We'll hear it on.
My lord.
Can 4 of 2025 is an application for on behalf of who has filed this can 4?
Pradeep Kumar, the second executor.
Acha. On behalf of one Pradeep Kumar, comma, the other executor of the purported will of late Siddhartha Ghosh, comma, than the deceased Brajendranath Mondal. Full stop. Next para. The said application is now taken up for hearing. Yes, deal with his point first.
Looks to the first line of the cause title of the application.
First title, first line is for leave to proceed with the.
Yes,
After
for
the
said
death.
appeal after the death of Brajendranath Mondal.
His cause of action for this filing
Cause of
this leave.
action, my lord,
It was represented. The estate was represented by Brajendra.
that appeal has gone. It's on the appeal.
That is hypertech.
Lord, it's very my lord, because he will now have to come up with why he didn't prefer this appeal for 6 years or 7
Because
years.
Brajendra was there.
Brojen was there. Now that is now his appeal is independently. He's saying he's representing Brojen. That can't happen. That your lordship has already rejected that.
No, we'll say that he's not representing Brajendra.
He has paid for that.
That is the cost title.
No, that's
He
his
seeks to implement he seeks the leave to prefer an appeal on the strength of his executorship in a will.
No.
Yes.
That is.
No. Have a look at it.
Petitioner being one of the
He
executors.
is
Yes,
represented by Sri Pradeep Kumar. Brajendranath Mondal, son of such and such, since
he has given the facts, Mr. Chatterjee.
Lord,
That would be
even in the
hypertech.
prayer.
We'll record your yes. See the prayer B.
My lord.
B is the substantive relief in this application. Leave be granted to petitioner Pradeep Kumar being one of the executors of Siddhartha Ghosh to proceed with the appeal.
But then for 7 years, what happens is once your lordship has said that there is no
Brojendra's appeal was within time.
Brojen's appeal was within time. Brojen's appeal has gone. My lord, by application of by my lord's order of my lord can 3, Brojen's appeal has gone. Something which has gone, my lord, cannot be revived by a leave to appeal. My respectful submission, my lord, there is no provision in the Civil Procedure Code which allows that. Because your lordship has rejected his prayer to represent him, Brojen's.
No, Brojen he cannot represent.
He cannot represent. So he can't go on with this appeal. His points may be different. He's a different entity altogether.
No, Because
He
my lord,
is.
kindly come to my annexer, my lord, last will and testament. My
He's not the he's not Brojane's representative. He will have a separate right if he has, he has. He's not Brojane's representative.
দুজন আলাদা দুজন এক্সিকিউটিভ সো ও এ এক্সিকিউটিভ হিসেবে এক্সিকিউটিভশিপ আর ওর এক্সিকিউটিভশিপ দুটো প্যারালাল সো এ তো নিজের আসতে আসতে আসেনি সেটা হচ্ছে এক্সিকিউটিভ করেছে লিগালি আর আসছে আসতে পারে সিকিউরিটি হিসেবে দুজনের ইন্ডিপেন্ডেন্ট কাছে লিগালি কথাটা হচ্ছে দুজনের হচ্ছে রিজার্ভারটা রিজার্ভারটা হচ্ছে উইল অফ পারপোর্টেড দুজন ক্লেমটা হচ্ছে দুজনের শিক্ষার্থীর স্টেটকে রিপ্রেজেন্ট করে দুজন করছিল বুঝতে পারছি first. Mr. Chatterjee, take your seat. We'll hear it.
My lord,
Yes.
regarding this point, I was, to be very frank, honorable court, that I was not prepared, my lord, on this point, because on the last occasion, it has been opined from this honorable court that there is a, my lord, paragraph 10, that
No, my lord, it's an interesting point. Let my learned senior friend. I'm also, my lord, I have no problems. If he wants to come prepared,
yes,
I
my
have
lord.
no problem.
That's why on this point, I have to take some instruction, my lord. Because it has been held, my lord, that applicant Pardeep Kumar is one of the executant of the purported will, is the legal representative of the deceased testator for all purpose, and the property of the deceased has also vested in him. As such, that definitely he has locus standi to proceed with the appeal. So I was under impression, my lord. Now, my lord,
We are still under that impression. Mr. Chatterjee has to dispel that.
yes, my lord. But because, my lord,
You are not the legal representative of Brojendra, but definitely you are the legal representative now of the estate of the deceased.
Absolutely.
my lord, may I
The
just
question
read
is
one
whether these
paragraph of the will?
two executorships run parallelly, independent interests,
No, my lord, what
or flow from the same
yes, my lord.
source. So that's why.
I appoint my elder brother-in-law, Sri Pardeep Kumar, son of late Madhusudan Kumar of such and such, to be the,
We are not.
be the
That is
joint
not in
executor of my will.
That is not in dispute. We'll decide it right now. Yes, we have heard you, Mr. Chatterjee.
Lord, this is not with respect to his rights. I am on the proceeding with the appeal which is filed, my lord, by Brojane. Brojane has gone by my lord's order, my lord. He is not the legal representative. He is
Nobody
not
says
the-
he.
My lord,
I
the
mean, at
rights-
least we don't say.
rights of an executor, my lord, they are not, my lord, jointly or severally. I can understand it's given in the will, but a right, someone is doing something, one person has come forward. He didn't come forward together. He was separate. If they had come forward together, my lord, this appeal would have gone ahead. If they had come together, there was no problem. But now he wants to proceed with an appeal which is filed by a dead man, and he is not the legal representative. Your lordship has held that in Can 3. I understand what is falling from your lordship in the sense, my lord, that there is, my lord, some sort of jointness, my lord, in the entire rights. But if they had come, the appeal would have been filed by, my lord. It's not a question of rights here. It's the appeal which is to be proceeded with. It's the appeal which is to be proceeded with. So Brojane, whatever he said, it's not that he is saying the same thing at the same breath. No. He is coming forward now to say that I want to go ahead as a legal representative. He is not Brojane's legal representative. He might be the testator's legal representative. And there also, my lord, there is a point. They had applied for probate, and that probate has been, my lord, dismissed for default.
No, my lord, that is pending.
So how much, my lord, they have a right
That's
today,
on
that
merit.
is also to be shown, seen by your lordship.
That's on merit.
On merit, even, my lord, because they want to, my lord, today they don't have a right to proceed. I say, my respectful submission. I'll come up with that. They today, with the probate being dismissed for default, The executor doesn't have a right.
That's all,
Doesn't
Mr.
have a right.
Chatterjee.
Well, that's
An interesting question has আগে বলেছি তো ক্যান ফোরটা নিচ্ছি an
just
interesting
come back.
yes an interesting question has cropped up in the present matter. Full stop. Next para. The impugned appeal is against the grant of letters of succession in respect of the estate of deceased Siddhartha Ghosh in favor of the respondent Srimati Jayanti Bose. Full stop. Next para. The appeal was initially filed within time by Brojendranath Mondal, one of the joint executors in the purported will left by the said deceased testator Siddhartha Ghosh. Full stop. Next para. While the application for leave was pending at the behest of Brojendranath Mondal, having been filed since Brojendra's prayer to implead himself in the succession certificate proceedings was turned down, the said Brojendra met his demise. Full stop. Next para. Learned senior counsel appearing for the respondent objects to the present application for leave to proceed with the appeal filed by Brojendra at the behest of the other joint executor of the purported will, namely one Pradeep Kumar. Full stop. Learned senior counsel argues that Pradeep Kumar does not represent the interest of the deceased Brojendra and, as an executor to the purported will, had an independent right to prefer an appeal against the impugned judgment and deemed decree granting succession certificate. Full stop. Since Pradeep never came up with any application for leave to prefer an appeal during all these years, as against the said Pradeep, the appeal has become time barred. Full stop. Thus, since Pradeep is neither the heir or legal representative of Brojendra, nor did he assert his independent right to prefer an appeal as an executor by filing the present application for leave to prefer appeal previously within the limitation period, it is contended that the present application ought to be dismissed in limine. Full stop. Next para. It is stressed by learned senior counsel for the respondent that the appeal has been rendered infructuous on the demise of the appellant Brojendranath Mondal. Full stop. Next para. However, learned counsel for the petitioner submits that the right to prefer the present application for leave accrued in favor of Pradeep only on the demise of Brojendra, since both of them were joint executors in the will left by Siddhartha Ghosh. Full stop. Next para. It is further pointed out by learned senior counsel for the respondent that the probate application has been dismissed in the meantime, to which it is submitted by learned counsel for the petitioner that an appeal is pending against this.
A miscase for restoration.
A miscellaneous case for restoration of the said ex parte dismissal is now pending. You are sure?
Probate application was dismissed for default. That has been filed an application miscase for restoration of that.
Yes.
And an addition of party. Order 1 Rule 10 application has been filed by this Pradeep Kumar before this.
This case was filed by whom? Brojendra?
This case was filed by Brojendra and next.
They have filed an application for addition of party on Order 1 Rule 10. And that is pending.
That is pending.
So, next para. It is clarified further that the restoration application was filed by the said Brojendra, upon whose demise, an application under Order 1 Rule 10 of the Code of Civil Procedure has been filed by Pradeep Kumar for being impleaded in the said restoration application. Push up next para. Be that as it may, the question which arises, which falls for consideration herein, is the juncture when the cause of action for filing the present application for leave to prefer appeal accrued in favor of Pradeep Kumar. Full stop, next para. We have to keep in mind that the rights claimed by both Pradeep Kumar and the deceased Brojendra before his demise STEM, from the self-same purported will of the testator Siddhartha Ghosh and are not independent rights divorced from the said will. Full stop. Next para. Thus, the rights of Pradeep Kumar and the deceased Brojendra are not parallel and independent, standalone rights, but since they were joint executors of the purported will of late Siddhartha Ghosh, the source of the uh, affectation of the rights of both Pradeep Kumar and Brojendra arise from the self-same purported will. Push up next para. In the facts of the present case, it is the estate of the deceased Siddhartha Ghosh, as uh, uh, bequeathed under his purported will, is what is sought to be protected by Pradeep Kumar as well as Brojendra, and not their independent title to the property in question. Full stop. Next para. Since, during all these years, the estate was sufficiently represented by one of the joint executors, Brojendra, by preferring the present appeal as well as filing an independent application for leave to prefer the same, there was no occasion for the other joint executor, Pradeep Kumar, to have come up with a similar appeal or an application, since the same would be a surplusage, as Brojendra was already sufficiently representing the estate. Full stop. Next para. Hence, the cause of action for filing the present application for leave to prefer the appeal arose in favor of Pradeep Kumar as and when Brojendra, who was all along representing the estate of the deceased Siddhartha Ghosh vis-a-vis his purported will, met his demise. Full stop. Next para. Contrary to the arguments of the respondent, it is not a fresh appeal, where Pradeep Kumar seeks to assert his independent right to the disputed property, but an appeal preferred by one of the joint executors previously to protect the estate as devolved through the said will. Push up. Next para. It is the self-same interest which is sought now to be protected by Pradeep Kumar, one of the other joint executors. Push up. In such respect, the mantle fell on the present applicant Pradeep Kumar only upon the demise of the previous joint executor, of the other joint executor. Full stop. Hence, it is the baton, BATON, of the estate bequeathed by the purported will of late Siddhartha Ghosh, which is now handed over to Pradeep Kumar upon the demise of the other joint executor, Brojendra. Full stop. Next para. From looking at the matter from such perspective, the right to prefer the present application for leave to prefer the appeal accrued in favor of the present applicant only on the demise of late Brojendra. Full stop. Thus, we are unable to agree with the contention of the respondent that the appeal has abated on the demise of Brojendra and cannot be revived at the instance of the other joint executor of the purported will of Siddhartha. Full stop. Next para. Insofar as the ex parte dismissal of the probate application is concerned, Since an application for restoration was filed by Brujendra, comma, upon whose demise an application for addition of party has been filed by the present.
It wasn't nothing ex parte. We were contesting. That's been dismissed for default. We were contesting.
No, আচ্ছা ডিসমিস এক্সপার্টি না পড়ে ডিসমিস ফর ডিফল্ট করে কোথায় ছাড়লাম
On whose demise an application for addition of party has been filed.
In connection with the restoration application by Pradeep Kumar, comma, the outcome of the same would decide whether a probate would actually be granted ultimately in favor of Pradeep Kumar as the executor of the purported will of late Siddhartha Ghosh. Full stop. Next para. Be that as it may, comma, it would be premature at this juncture to hold either way, comma, as to whether the probate application would be restored and ultimately probate granted, and stroke or the restoration application stroke addition of party application would be dismissed, and or even upon revival, comma, the probate application would ultimately be dismissed again. Full stop. Next para. Only time can answer such questions. Full stop. Next para. However, comma, insofar as the right to prefer an appeal is concerned, comma, we are of the opinion, comma, in view of the aforesaid circumstances, comma, that Pradeep Kumar, comma, who claims himself to be a joint executor of the purported will of late Siddhartha Ghosh, comma, is sufficient to grant leave to prefer the appeal. Full stop. Next para. Accordingly, Can 4 of 2025 is allowed, comma, thereby granting leave to the applicant Pradeep Kumar to prefer the appeal bearing FA 46 of 2021 against the impugned judgment and deemed decree granting succession certificate in favor of the respondent. Full stop. Next para. Any other application? So we'll direct paper books to be filed. Paper books. In view of the appearance of the sole respondent through her learned advocate, comma, service of notice of the appeal is dispensed with on the respondent. Full stop. The appellant shall the trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. Full stop. Next para. Upon the service of notice of arrival of the trial court records on the learned advocate for the appellant, comma, the appellant shall prepare and file the requisite number of paper books within 8 weeks thereafter. Full stop. Leave is granted to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. So এর আগে করে দাও Can 4 of যেখানে allowed করলাম necessary correction in the cause title of the memorandum of appeal shall accordingly be carried out by the learned advocate on record for the petitioner, comma, impleading the name of Pradeep Kumar as the appellant in place and state of Brojendranath Mondal, comma, the deceased other joint executor. Full stop. Such correction shall be carried out during the course of the day.
Only one thing, my lord, Can 1, that is old number 7212, 2018. That was the stay of the proceeding filed by the Brojendranath Mandal since deceased.
We asked you whether there is any other application.
Yes.
You said no.
That number 1, my lord.
Stay of what?
That can
Stay of that
can
proceeding.
be. There cannot be any stay of the proceeding. It's
Stay
been
of
granted.
what?
Stay of, my lord, that
Succession certificate decree? No. Since next
filed
line
by my lord Brojendranath Mandal.
Can 1 of 2018 within bracket old number Can 7212 of 2018 bracket closed is an application for stay of the impugned succession impugned judgment and deemed decree granting succession certificate in favor of the respondent. Full stop. However, comma, grant of such relief at this stage would tantamount to allowing the appeal without hearing it on merits. Full stop. As such, comma, Can 1 of 2018 be is 2018 is disposed of without granting any stay. Full stop. This will, comma, however, comma, not prevent the appellant. Will not put that in our order. You can file an injunction application if you like, but we will not put that in our order. That will be granting you sanction.
Can't say directly say it in there.
Yes.
Grateful, Your Lordship. Much
File an injunction application so that Mr. Chatterjee's client is restrained.
grateful.
Yes.
Much of.
My lord, I am for the appellant applicant. My
Yes, Mr. Mukhopadhyay.
two applications, my lord. One for one. Can 2 is for section 5
Achha.
of the Limitation Act for condemnation delay in
What is the
filing
delay?
a delay is, my lord, within the pandemic, my lord.
Entirely within the pandemic?
Yes, yes. But kindly see from the judgment and degree in the memorandum of appeal, my lord. It is
Yes.
applied on 1st of October 19 is my lord,
2019.
2019, 1st of October.
So the limitation period is 90 days. November, December, January. Before pandemic.
No, my lord, I applied for the certified copy on 1st of November 2019. But then 28 January 2021. Kindly see from the first page
Copy
of
was ready on 30th of January. Copy was ready on 30th of January. 2 months before the pandemic.
2021, that is within pandemic, my lord.
Oh, 2021.
2021.
Sorry. 2 years after.
Yes.
Copy was prepared.
19, 20.
And when did you prefer the appeal?
And my lord,
when did you file the appeal?
I filed the appeal, my lord, only September 29th of September 2021.
But you have to serve a copy.
Well, I have served a copy upon there are 10 respondents, man. This is the difficulty, man.
So you have to serve copy.
5 has come back, my lord. 5 I have.
Was there a direction for service?
No. Before
Then
mentioning,
that service is meaningless.
my lord,
that service is meaningless. Serve on all the respondents.
I'll serve, my lord. Then
we'll direct you to serve copies of both the applications
Both
so
the
that when they come, we'll allow this and then take up the other one.
my lord.
The appellants shall serve copies of Can 1 of 2024 and Can 2 of 2024 on the respondents' opposite parties, indicating that the applications shall be listed on April 9, 2025 under the heading application, which of the appellants shall file an affidavit of service to that effect on the returnable.
But can it be 1 week thereafter, my lord? Instead of 9, there is a Annapurna Puja.
9th না করে 16th করে 16 রিটার্নেবল ডেট 16th
16, my lord.
এটা লিখে নেবেন ওকে বলো তো
চলো কি হবে এটা কি করব আর করতে হবে অ্যাড্রেস
yes
Lordship, I'm appearing.
lingering the litigation, taking advantage of
Lordship.
Yes.
My learned friend has given this reply today.
Why, Mr. Jha?
Lordship, in the
Will
meantime,
impose costs on your client.
Lordship, in the meantime, Lordship, certain holidays are there, and due to that reason, I'm bound.
What certain holiday? Only holiday.
Lordship,
No holiday. Other than
And
holiday.
due to that reason, your Lordship, I am
What reason?
unable to serve the copy.
This is not the
Due to that reason, only your Lordship.
earlier.
Anyway, let us not waste time on costs. Are you? Can you argue today? Will you take it up? What is the appeal? The appeal is against what?
Lordship, against the order of the.
It is a stay application.
STO has been already granted, your Lordship, till disposal of the appeal, your Lordship. But till
Disposal of the appeal or
ST
application?
Till disposal of the ST application.
Yes. What is the appeal against?
Appeal against the order dated 9th.
No, what was done by that order? You are the defendant.
I'm in the suit defendant.
What was the plaintiff suit for?
Suit for declaration and permanent injunction in respect to suit shares, your Lordship. Plaintiff himself declared that the plaintiff is a share broker, and he has purchased the suit shares before the secondary market.
Mr. Jha, it has been a decree has been passed declaring his title in the shares.
In the shares, your
And what sort of injunction?
Lordship, regarding injunction before the trial court, your Lordship.
The decree, impugn decree.
Lordship,
You are asking for a stay of the impugned decree. What was done by the impugned decree? Declaration of his title to the shares and
there in entire that is your lordship. In short, I'm telling you, Lord. I'm coming. I am the purchaser. The bona fide.
bona fide or malafide will decide.
That has been decided by the trial court. Adjudication has
We are
been
in appeal over that. So we'll decide ultimately. Let us just check up what is the decree for. Bona fide purchaser, no title interest, restraining from transferring. Shares of State Bank of India.
Lord, State Bank of India.
So you have been injuncted from transferring during pendency of the suit. How can there be a stay of this?
Lordship, before filing of the suit,
don't transfer the shares in favor of third parties.
Lordship, before filing of the suits have been transferred in the
Might have been that, but
filing of the appeal.
Mr. Jha, we cannot grant stay of this decree. If you grant a stay of the injunction, that will open up. You can now transfer.
No, your lordship.
What will be the effect of that?
I'm not transferring at the.
We granted stay. We'll recall that stay order. What was the stay granted? Let us see. Yes, only the declaration portion was stayed.
Lord.
So that they cannot deal with the share.
Lord.
Injunction cannot be stayed. We granted a stay of insofar as the decree declares that the plaintiff respondent 1 is a bona fide purchaser. But the other portion, permanent injunction, we won't touch now.
No.
Yes, now, Mr. Garg, if that portion is not stayed, you have been declared to be the bona fide purchaser and the owner. You will be able to deal with the property. If you deal with the property, then nothing remains in the appeal. It will be rendered infructuous. So that portion will remain stayed, but the permanent injunction, they will also not be able to transfer in favor of third parties. We are not touching that part.
I submit. First, my only submission is who is he?
Not he, it. State Bank.
Interested parties only respond number 3 to 48. They never.
They are the company.
This is the.
I mean, they are the bank of whose shares you.
You share to deal in the market. No loss and profit to the State Bank of India. I am the bona fide purchaser. I purchase the
So
share.
since they have prepared an appeal, we'll have to decide the fate of that. They are the company of whose. You have a point there, because but it's their shares. You are seeking a declaration. You have been given a declaration that you are the purchaser. They deny that purchase. They are the company of
How
which.
they can deny my purchasing the share? I purchased the share from the share market. The broker of the stock exchange.
No, was there any registration under Section 108 of the Companies Act? It is governed by the 56 Act.
Yes, my lord.
Was there a registration under Section 108? We have to see whether the specimen signature of the transferor was produced before them. They compared that specimen signature with yours.
Let them produce the
transfer deeds.
Yes.
We'll look into the evidence. No, at this stage, we'll grant stay. We'll continue the stay.
And let them produce the transfer deed.
That he'll do in the.
Even though whether they served
the appeal will decide that.
My lord, whether they served upon the respondent number 3 to 48 or not.
Heard learned counsel for the parties. First of the present application is for stay of operation of the impugned decree, whereby it was inter alia declared that the defendant, that the plaintiff.
My lord, first I can see the written statement, nothing else. I don't want to.
What that is on what?
The written statement. Written statement of the appellant. It is written in by them. If the trial court adjudicate the sale in my favor is the adjudication, they have no objection to issue the sale in my favor. Can turn to their written.
So show us the written statement.
Yes.
Lordship, regarding that.
Show us that. Show us
yes,
that.
Sure.
Lordship, I submit to your lordship regarding. If
No, we'll hear you on that.
No.
He is opposing your stay. Let us see.
No.
Take your seat, Mr. Jha. We'll just hear Mr. Garg first. Yes. Where is it annexed, Mr. Garg? Give us the page number.
Page number is finding out this whose petition is made me know.
You don't have a note beside your brief.
No.
We don't find the written statement in the state. At least you must have annexed in your opposition then.
When the plaint was there, my lord, I did not. I think I annexed with the plaint.
If you don't have a copy of the written statement, how did you know there was an admission?
They have annexed, my lord.
You don't even have a copy of the written statement.
Just a minute, my lord.
Lordship, in the written statement, page number 108 of my stay application, I have mentioned in paragraph number B that the present suit may kindly be dismissed as against the defendant number 1 and 2 without passing any order as to cost and compensation against the defendant number 1 and 2. And Lord, I have prayed before the court in respect to dismissal, your Lord. And second point, your Lordship, if the suit shares has not been purchased by the plaintiff.
No, you did not object to their ownership in the written statement. You have washed your hands. You have said the plaintiff's claim for the share certificates may kindly be adjudicated
Yes,
against
my lord.
defendant number 3.
Paragraph 8.
Yes, we are on paragraph 8.
Yes.
Page 107.
They are admitting itself, my lord.
They are neither admitting nor denying.
Yes. Adjudication is to be made. If the adjudication is made in my favor.
But there is no specific denial on your part in your written statement against their ownership.
Your Lordship, if the judgment and order erroneous, then the defendant has not any right to approach before your Lordship.
Where is your locus standi to prefer an appeal?
Your Lordship, the suit shares issued by the bank. Your Lordship, the suit shares has been purchased.
It is not by the bank. Bank appeared and your shares, but you appeared and said you did not raise an objection. Para 7, you say, in view of the above submission, is respectively submitted, suit may kindly be dismissed for want of cause of action against defendant numbers 1 and 2. And the defendant numbers 1 and 2 have no objection if after adjudication of this matter by and between the plaintiff and the defendant number 3 to the orders for declaration on title are conferred upon the rightful claimant. There is no denial. This is evasive, not even evasive. You are not denying his title.
Lordship.
Show us one paragraph from the written statement you have denied his title. Show us one paragraph. Rather, at page 104F, clause F, you say that it is respectively submitted that contention of plaintiff that 2700 shares claimed to have been purchased by him had fallen into some unauthorized hands is their own presumption for which defendant number 1 has no comments.
Lordship,
Don't have a prima facie case first.
Page 102, your Lordship, the suit is not maintainable in its present form. That the suit is hit by law of limitation. That not maintainable in its made by the
Bring us any written statement, we will find out these paragraphs from. In every written statement, these are general omnibus defenses.
Lordship,
Why have you said? Where have you stated the specifics? Why is it barred by law of limitation? Why is it not maintainable in the present form? There is no pleading on that.
Lordship, suit is
These are usual omnibus defenses.
Lordship, generally the suit shares already decided by the SEBI Act, your Lordship.
Mr. Jha, show us from the written statement you have disputed their ownership. Show us that from your written statement. We are waiting for that still. Show us. Your written statement is before you. Show us.
Lordship, no doubt.
Only show us that. Unless you show us that you have disputed their title, you don't have a prima facie case. He's right.
Lordship,
show us. It will not be written on my face. It will be written in a written statement only. The other defendants contested, Mr. Gar.
It did not never appear a single by served upon them all the defendants.
They are the transferees.
Yes, my lord, according to them. But no.
Defendant number 1 are not aware about the purchase of shares by plaintiffs. কি বলছে? না না ঠিক। If, no, we are not contesting. Plaintiff stroke respondent number one is the bona fide purchaser of the disputed shares, comma, which are the subject matter of the appeal, comma, that the defendants do not have any claim to such shares, and permanent injunction restraining the present appellant within bracket defendant number one in the suit, comma, from transferring the suit shares in favor of third parties. To the next para, learned counsel for the appellant argues that this court had granted an ad interim stay in respect of the portion of the decree whereby the declaration regarding the title of the plaintiff was made. First of that apart, comma, it is pointed out that objections as to maintainability of the suit and other defenses were taken by the defendant stroke appellant in the suit itself. First of next para, learned counsel for the appellant submits that since the shares in dispute belong to the present appellant, comma, the appellant has the locus standi to prefer the appeal. Which of next para, learned counsel appearing for the plaintiff stroke respondent number one submits that insofar as the other defendants are concerned, comma, the decree was passed ex parte against them, comma, since they did not contest the suit. Full stop. Insofar as defendant number one is concerned, comma, it is argued that the said defendant within bracket present appellant bracket closed, comma, virtually did not deny the plaint case at all in its written statement, and as such, comma, the appeal is not maintainable at the behest of the appellant. Full stop. Next para.
Lordship, so for my Lordship, allow me 1 minute time to satisfy your Lordship regarding some questions here.
We have given you much more time than 1 minute. You failed to
Lordship,
satisfy. We are in the midst of our order.
Lordship, please, your Lordship. Lordship, kindly allow me to move on.
Yes, yes.
Lordship, plaintiff declares himself that he is the bona fide purchaser, your Lordship. And plaintiff also declares in the suit shares that the plaintiff has signed the transfer deed and stamped the transfer deed and sent the transfer deed before the State Bank of India, your Lordship, for transferring their names, your Lordship. But in the transfer deed, your Lordship, no any transfer deed has this put the signatures of the plaintiff, put the seal of the plaintiff.
Which paragraph of your written statement says that? Which paragraph of your written statement?
Lordship, remand back.
We are still waiting for that. Anyway.
Lordship, this is the fact.
Please, Mr. Jha.
Lordship, what?
Please, Mr. Jha. Enough is enough. Yes.
So far as the defendant one is concerned, it is argued that the said defendant virtually did not deny the plaint case at all in its written statement, and as such, the appeal is not maintainable at the behest of the appellant.
Next. Learned counsel for the appellant bank seeks to point out several drawbacks in the plaint case, which of it is submitted that insofar as the transfer deeds, comma, on the strength of which the plaintiff claims title to the shares are concerned, comma, those were not sent to the appellant. Full stop. However, comma, upon hearing learned counsel, comma, we are unable to find a single sentence of pleading on such count in the written statement filed by the defendant number one stroke appellant in the trial court. Full stop. Next para. The first appellate court sits in judgment over the verdict of the trial court and cannot act as an independent trial court. Full stop. Next para. As opposed to the present contentions of the defendant stroke appellant, comma, we find that apart from certain omnibus defenses omnibus, vague defenses regarding maintainability of the suit, the same being hit by limitation, and non-joinder and misjoinder, there was no specific averment of denial to the plaintiff's case of title to the shares. Push up next para, rather, in paragraph 6, clause small d, the defendant number 1, small d of the written statement, the defendant number 1 states that the defendant number 1 is not aware about the purchase of shares by the plaintiff from defendant number 3, since such facts are within the special knowledge of the plaintiff and defendant number 3, for which they may be put to strict proof of their contentions. Push up again, in clause small e of paragraph number 6 of the written statement, the defendant number 1 washes its hands and seeks to shift the responsibility on defendant number 2 on the ground that the transactions pertaining to the shares, including transfer and stroke or dematerialization, was handled by defendant number 2. Full stop. Next para. In clause small f of paragraph 6 of the written statement, the defendant number 1 states that the contention of the plaintiff that the 2700 shares claimed to have been purchased by him had fallen into some unauthorized hands is the plaintiff's own presumption, for which the defendant number 1, the italic say, has no comments. Push up. Next para. In paragraph number 8 of the written statement, the defendant number 1 states that the plaintiff apostrophe's claim for share certificates may kindly be adjudicated against defendant numbers 3 as well as the original holders who are the alleged sellers of the certificates and the NSDL for one certificate as mentioned in paragraph 6K therein above. Pushed up. In paragraph number 9 and its subclauses, it is stated by the defendant number 1 that since the defendant numbers 1 and 2 on receipt of the suit has marked stop on all the certificates except one which has been dematerialized and have been provided the relevant detailed status of these certificates in the form of Schedule A to the written statement, the suit may kindly be disposed of by passing necessary orders about the declaration of title of the suit share in favor of the rightful claimant as deemed fit at the nature and circumstances of the case, and also that the present suit may kindly be dismissed as against defendant numbers 1 and 2 without passing any order as to the costs or compensation against the defendant numbers 1 and 2. Pushed up. Thus, the entire premise of the defendant number 1 in its written statement was that it had no direct knowledge and or shirked responsibility regarding the contentions raised in this suit. Full stop. In the absence of any specific denial to the ownership of the shares of the plaintiff, we are unable to find any prima facie case for continuing the ad interim stay granted by us. Full stop. Next para. It is well settled that ad interim orders passed at the initial stage are not binding at subsequent stages of the application for stay, upon the same being heard on merits upon giving opportunity of hearing to both sides. Post of next para. In view of the above observations, Can 2 of 2023 is dismissed without any order as to cost. Full stop. Next para. The in view of appearance of the respondent plaintiff stroke respondent number 1 through its learned advocate, service of notice on the respondent number 1 is dispensed with. Pushed up. Since the other respondents were other respondents and pro forma respondents were defendants in the suit, other defendants ultimately contested. None of the other defendants contested.
I served upon them all the defendants.
Paragraph number 10, I have said
But did not contest
kindly
the
consider
proceeding,
paragraph
service of notice of appeal on the said defendants, said respondents and pro forma respondent be dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of appeal on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Sorry, Mr.
I'm much.
We'll take up the next matter after 5.
This
Yes. Colin.
Lord, I appear for the plaintiff opposite party. My lord, I
Opposite
have
party.
received,
Your
my
full
lord,
petition.
Yes, my lord. My lord, I'm
copy of
appearing.
the stay application.
I'm appearing on behalf of the appellant, my lord. My lord, I was going to pray for not today.
You are not told that the judge would refuse?
My lord, Mr. Patho Chakravarti is appearing
I
in this matter,
understand,
my lord.
There is an order of stay, my lord, passed by your lordship, my lord, on 10th February 2025 against the, my lord, judgment and decree, my lord. It was suit, my lord, for specific performance.
Specific performance.
My lord.
So we'll dispose of the stay application
My lord,
direct.
my lord, I think, my lord, if your lordship grants me leave to file affidavit, I tell you, lordship, perhaps this matter can be disposed of on the application stage itself.
Why do you say that?
My lord, I tell you, lordship, they have taken the point that the learned court below, my lord, did not impound the document. Now, my lord, it has to be seen whether that document itself was required to be impounded or not, whether that was at all an agreement for sale or not, or an agreement to enter into an agreement. Now, my lord, there is a Supreme Court judgment to that effect also, that in case, if, my lord, this point was not raised by either of the parties at the time of trial, if even when the document went into evidence, my lord, perhaps they cannot
Section
take it.
36 is there. Stamp Act.
My lord, whether, my lord, it has to be gone to, my lord, whether the document was compulsory registrable or not, my lord. I have to see to it, my lord, yesterday. I got the
Registrable, yes. Stamp Act does not alleviate that.
because whether it was an agreement for sale or not, whether it was an agreement to enter into
At
an
the
agreement.
appellate stage, you will decide that. At the
My lord,
application
it is
stage,
the only point which they have taken. Other points I see, my lord, they have not
you
given.
can prepare paper books, but at the appellate stage, you will decide. You have to go into the materials.
Kindly grants me the leave and file an affidavit in opposition. I have just received it.
It will only perpetuate what no new allegation has been
That
made.
even, my lord, after hearing, if your lordship finds, my lord, it has to be heard in appeal, then your lordship can, my lord. Only this opportunity I was asking. my
Very
lord.
well. Learned
Through which
counsel,
time was the frame?
learned counsel for the respondent seeks an opportunity to file affidavit in opposition to the present application. So accordingly, the respondent stroke opposite party is directed to file affidavit in opposition within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Full the application shall be listed next on April 22, 2025 under the same heading.
Mal, I'm grateful. Mal.
Grateful, my lord.
Interim order was still disposal of the application.
Still disposal of the application. Mal.
For the respondents, opposite parties, well, there was a direction for filing affidavits. Well, I have served my learned friend. I am filing the affidavit in opposition. Let him file reply, my lord. Your lordship may fix a date.
My lord, the opposition was filed, my lord, though it was filed beyond time. I think, my lord, reply is not necessary. Though I have filed, my lord.
Then your
It's
lordship kindly fix a date. I will come with some.
Why fix a date? We'll take up the application. What is the application for?
My lord, application is for injunction, my lord, appeal arising out of a grant of probate.
Stay. You have asked for
My
stay.
lord, that is in the prayer.
Oh,
portion, that is
yes.
probably,
Already he is enjoying that order of
Injunction.
injunction till disposal of the application.
What have you said in your opposition?
I have said, my lord, they have relinquished their right title interest by registered deed. Thereafter, they are objecting to this application.
But on the face of it, this is
Just a minute, sir.
The decree is for what?
Not a degree, my lord. It is they have challenged an order of granting probate, which has.
That's a deemed degree.
My lord.
So they are challenging probate.
Yes. Your lord, if your lordship kindly comes to page 38, it starts.
Of your opposition.
My opposition.
Mr. Shabul, let us hear him first, because let us hear his objection. Otherwise, you are entitled to a stay, obviously.
Just a short, my lord, no point, my lord, with regard to the compromise or whatever relinquishment of share, it relates to estate of another person, and we came with regard to estate of another person.
No, not correct.
Your lordship.
That's why let us hear them first.
Your lordship.
Yes.
It starts from page 38.
Of your opposition.
My opposition. And
the will was left by whom?
By our mother.
Name?
Chitarani Bose.
Chitarani Bose. And she got the estate of her husband. Now, if your lordship kindly comes to the ultimatum portion, that is page 43.
Yes.
May I place, my lord? আমরা দ্বিতীয় পক্ষগণ এই ফ্যামিলি অ্যারেঞ্জমেন্ট এগ্রিমেন্টের করিয়া এর দ্বারা জানাইতেছি যে আমরা দ্বিতীয় পক্ষগণ আমাদের পূর্বাধিকারী অধুনা মৃত হরিপদ বসু মহাশয় তাকে যাবতীয় স্থাবর অস্থাবর কোনো সম্পত্তিতে আমাদের কোনো দাবি দেওয়া থাকিবে না। ইহা প্রথম পক্ষ তিন ভ্রাতা ও আমাদের মাতা অ্যাবসলিউট রাইট ও ভোগ দখল করিবে। Lordship kindly appreciate.
That is being relinquished by Kamal Kumar Bosu.
No, that is
To
relinquished by
দ্বিতীয়
the,
পক্ষগণ,
yes, by the daughters Rima Ghosh Chaudhuri, Meena Ghosh, Krishna Ghosh, Hena Ghosh, Alpona Ghosh, and my lord
আচ্ছা,
Shantana Bhanjo. And they have filed this application.
they relinquish their shares in the property,
yes,
in favor of inter alia their mother.
Mother and brothers.
All right.
Now-
Now this mother has left her will.
No, mother.
Mother has left her
Yes,
will. This
bequeathed
Shitarani.
the will in favor of his sons and one grandsons because
You say that since they have already relinquished title in
My lord.
respect of the property.
yes, and already record of rights.
No, but Mr. Mitro, there is something else here. Now they have relinquished, they were also co-owners. They
Yes.
relinquished their independent rights in the capacity of co-owners.
Yes,
So their rights they have relinquished.
yes,
But they are heirs to Shitarani also upon her demise. So as far as Shitarani's share, they might have relinquished their own shares in the property, but they are entitled to Shitarani's share by succession, unless there is a will. Therefore, they have a caveatable interest
but
regarding
there is-
Shitarani's estate.
yes. So far the will is concerned, my lord, there is no allegation, my lord, that the will has been granted.
That will decide on merits. They must have taken some defense.
And so far mutation, as because your lordship has been pleased to injuncted me selling, transferring, my lord. So far mutation also stands in my name, my lord. I have already.
Whatever you have done. But from the day of the injunction order, you cannot do it.
No, that I understand. But here, if your lordship kindly, my lord, comes to once the order, I have annexed, my lord, that is starting from page 15. And judgment is at page 18.
That will decide at the final hearing of the appeal. Judgment, why are you taking us to the judgment itself? What order did we pass? Where is the injunction order? What is the date? January 14th, yes.
Yes, that your lordship has been pleased to pass.
Selling, transfer, and
Yes,
income.
encumbering the properties.
Don't encumber the property or change nature and character. Mutation, if you have done, you have done.
They are in possession, let
Yes.
them
Don't.
possess.
We are also not disturbing your position. Don't
That
change the
your
nature,
lordship
character.
kindly-
Don't transfer.
Then that your lordship kindly indicate that so far my learned friends, clients are concerned, they may not also disturb my position.
You have not filed an injunction application.
No, that I have not.
Then
But your lordship
What
has
is the allegation that they are doing that?
no, but your lordship has ample power, my lord. Your lordship
Think we have. We
have.
don't have.
Now
We
so
think
far,
we have.
only
Don't have
one
the.
thing, my lord. My lord, so far the order of the probate is concerned, my lord. Everything has been done, my lord, in accordance with law. Now they have filed the written objection. If your lordship kindly see,
Oh, we'll
your
decide
lordship
at the
doesn't
time. of
want
decision.
to go right at this moment.
That is on the merits of the appeal. How can you hear that at this?
Yes, that's true.
This is not a mini trial of the appeal.
That's true. That's true. But your lordship, as well from your lordship, that mutation stands in my name. So your lordship kindly also give me some protection. I'm not going to transfer.
You are not seeking any protection. Why should you give you protection? They are seeking protection. We are granting them protection. Affidavit in opposition filed today be kept on record. Full stop. Although the affidavit in opposition has been affirmed beyond time, comma, we accept the same. Full stop. Learned counsel for the petitioners argues, submits that in view of the averments made in the opposition, comma, no further reply is necessary and the application may be taken up for hearing. Full stop. Next para. Heard learned counsel for the parties. Full stop. Learned counsel appearing for the respondent numbers 2 and 3 places reliance on a family arrangement agreement
registered
annexed at page 38 of the affidavit in opposition. Full stop. It is contended that by such registered document, comma, the present appellants had relinquished their title in the property. Full stop. Next para. Learned counsel appearing for the respondent numbers 2 and 3 further submits that in view of such relinquishment, the appellants cannot resile from such position now and claim to have a caveatable interest in the property and or a right to prefer an appeal. Whose of next para, learned counsel for the appellants points out that the relinquishment was in respect of the shares of the appellants with regard to the total joint property. Whose of however, on the demise of late Shitarani, the predecessor in interest of the parties, who was the testator of the will in question, her share, the appellants also derived shares in her property. Full stop. Next para. Upon a careful perusal of the family arrangement agreement, we find that by virtue of the same, the present appellants, who were co-sharers of the property, relinquished their own shares in the property. Full stop. However, by the self-same arrangement, late Shitarani Bosu, the testatrix, derived interest in the property, which she subsequently bequeathed by virtue of the disputed will, in respect of which probate has been granted by the impugned judgment and decree. Full stop. Next para. Hence, although the appellants relinquished their own shares in the joint property, fact remains that as some of the heirs and legal representatives of the deceased testatrix, the appellants also have a right, in the event there was no will, to the property through the testatrix. Thus, the appellants have sufficient caveatable interest in the matter of grant of probate, and as such, are entitled to prefer the appeal. Next para. Since the present first appeal is required to be adjudicated both on facts and on law, we find sufficient prima facie case to continue the ad interim injunction granted by us earlier. Accordingly, Can 1 of 2024 is allowed on contest, thereby restraining the respondents by an order of injunction from selling, transferring, alienating, and or encumbering the suit property in favor of any third party, and or changing the nature and character of the same till disposal of the application. You are not appearing for respondent number 1.
No.
You have served on respondent number 1.
All, sir.
Very good. Next para. In view of appearance of the respondent numbers 2 and 3 through their learned advocate, service of notice of appeal on the said respondents is dispensed with. Full stop. Next para. Who are the other respondents?
My lord, they are the
apart from 1 and 2
daughters, my lord, who were defendants but not the appellants before.
But notice should be served on them
Yes, my
also.
lord.
They have interest.
Initially, I have served them. They received.
No,
they
regarding
yes,
that.
my lord,
Only one line.
notice of appeal.
My lord, if your lordship kindly record my submission that in affidavit in opposition paragraph 6, I have stated.
No, we have passed over.
No, I'm not on this.
The
order of
respondent,
injunction.
insofar as the non-appearing respondents are concerned, the appellants shall put in requisites for service of notice of appeal on them within a week from date. Full stop. The trial court records be brought by special messenger at the cost of the appellants, also to be deposited within a week. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Who have liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
That's good.
Thank you.
I'm filing my.
But if mine is the apparent. The last token here also is directly my learned friend. Only defendant number 2 has entered appearance. Is that
This is opposition to section 5.
Section 5, man. Section 5 and supplementary.
And you also directed him to have copy of the application.
Where is the supplementary affidavit, Mr. Bhattacharya?
I have last occasion
You have filed? Yes. It's there. Hey, এটা খুলে দিন।
Then 3rd March.
কেটে দিন এটা।
And you also were directed
কি করছেন বড় পড়ে
to
যাচ্ছেন?
file affidavit in opposition within 3rd March and reply by 10th March. But I received the copy on 12 March.
So reply you haven't prepared.
I have not, it's not. It's a super party, sir. My share has not been deleted. I did not get any
No, no. Do you
summons.
want to use a reply? Either you take up the application or you don't. If you want to use a reply, we will not take up the application. If you don't want to use a reply, then we'll hear you on this.
Because my only contention summons have not been served.
Whatever is your contention, is what is it?
I have given reply. Otherwise,
Why waste time?
That defendant has stated summons have been served.
We can hear the application without
I have
reply
given
also.
reply.
What is this?
This is
Acha,
service.
affidavit of service filed today. You are appearing for all the respondents.
No. Defendant number
No, only
three. What about the others? Service?
other service last occasion, sir. But on respondent number 6,
I mean, respondent 3. Respondent number 3.
return back insufficient address.
The others have been served.
So
So what about respondent number 6? You have to
6
serve.
one of the address that was in the that mentioned in the plane. I have served copies, but return back insufficient address.
This arises from what suit?
Food for party, sir.
Partition model.
Acha, respondent number 6. Respondent number 6 was one of the plaintiffs.
One of the no defendant.
Plaintiff is respondent number 1.
So defendant was served. Defendant number 6 contested the suit
Yes. File written statement. Yes.
at the same address.
Same address. All the defendants stated they have no objection.
Affidavit of service filed today be kept on record. Full stop. Apart from the respondent number 6, comma, all the other respondents have been served.
Yes.
Full stop. Next para. Insofar as respondent number 6 is concerned, comma, learned counsel appearing for the appellant points out that the service was sought to be effected at the address of the said respondent as given in the plaint in the trial court, comma, from which address, comma, she contested the suit. Full stop. Next para. Hence, comma, we find that sufficient service has been effected on the respondent substantially. Full stop. Next para. The affidavit in opposition filed by the respondent number 3. You are 3.
I am 3.
Respondent number 3
And
to the application for condonation of delay and the supplementary affidavit be kept on record. Full stop. On the prayer of learned counsel for the appellant, comma, the time for filing reply is extended for a week from date. Full stop. The matter shall next be listed on March 25, 2025 under the same heading. Please give them the copy of that reply a bit earlier so that they can come.
I have to serve reply only to Mr. Mukherjee, nothing. And nobody entered.
Nobody is appearing. Nobody is.
Respondent number 2 is father of appellant mother.
Partition suit.
Partition suit.
Father, mother, brother,
mother.
partition suit. There is no, all are enemies.
Might have received mother.
Unless it's collusive.
No, defendant 1 and 2 file written joint written statement.
1 and 2.
His client.
Your father and?
Father and myself mother.
Myself is who? His in relation to
No,
him?
I did not get any summons. That is appellant, sir.
What is the relation between you and him?
Brother. But not the mother.
I did not get any summons.
Hey, নিজের brother.
That is why my share
Cousin
that
brother.
gifted my grandmother. That has been I did not get anything.
Sorry. The next one.
The state respondents.
State.
But Lordship, last order.
Last occasion?
In the last occasion, Your Lordship, pursuant to Your Lordship's earlier order, a fresh report has been awaited, still awaited.
What
in
is the fresh
respect of-
report regarding?
In respect to inclusion of my name in the, by the erstwhile name has been changed.
Filed or not, my lord? I believe.
That report may have come, my name has been included on the last occasion.
What
I mean, I have gone to the department and included my name. I have verified the,
You filed a no objection.
yes, my lord. Report may have come.
Yes, no objection has been filed.
Yes, my lord.
That report is here.
Yes.
So let us take up the matter. Section 5, what is the
My
reason
lord,
for the delay?
today, I have filed a Can 1 in regard to the section 5.
What is the reason for the delay?
My lord, reason actually the man who is the appellant against whom I am appearing before this.
For whom you are appearing, yes.
That young man since 1986.
Young man?
At that time, he
Oh,
was
say that,
young.
68
Now,
years?
now at the age of 69, my lord. Here, naturally, he becomes a fragile and feeble.
So
That
how
is
does that
why
explain the
material
delay
point
of
of time-
29 days?
My lord, I am explaining, my lord. I'm reason has been explained by me. That is why he was, as he was feeble and fragile, he could not come at the
Mr.
material
Bosumalik, we
point
are
of
allowing
time.
this section, please.
Only more or less,
Upon hearing learned counsel for the parties,
That is the
we are of the opinion that sufficient explanation for the delay has been given.
my lord.
Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 93 of 2024. Push up. The said appeal is accordingly deemed to stand registered and admitted. So, any other application?
My lord, there is a memorandum appeal and also an application for
No other
stay.
application?
Can 2, my lord. Can 2, the stay application, and memorandum
Okay.
appeal also filed, and no other, because of the learned trial court is, everything is
The
recorded.
appeal is against what? What is the decree? Impute
The
decree?
matter is, an order of division bench, constitutional division bench has been
You are
passed.
challenging what decree in the appeal?
I'm explaining.
Don't explain, just answer us.
The learned trial court has passed an order whereby my payer, which has been considered by the learned division bench, that he should be approached before the learned civil court
Your
for
suit has been
appropriate
dismissed.
compensation.
Your suit has been dismissed.
Yes, my lord.
Where is the scope of any stay of that? It was a money suit.
Yes, money suit.
Money suit dismissed. How? What is the meaning of staying there? Suit will revive.
Well, should be revived, and the
Money
justice
suit. If
may
there
be
is a
done.
positive direction for someone to pay something, we could have understood.
Yes,
stay.
state government.
Suit has been dismissed. Where is the question of stay? What will we stay? Dismissal of the suit.
Is still because substantive justice has not yet been given to me. Compensation has not yet been, because the
What is
order
the
of
effect of stay of a dismissal of a suit? What will happen if you stay the suit?
because
If they stay the degree,
justice has not yet been rendered to me.
that is a ground for grant of stay. What is the effect of grant of stay? If you stay the dismissal of the suit today, what happens? The suit will be revived and it will be heard again.
That has
It will be deemed to be pending
my lord, in that case, I have to take instruction
from your client.
My lord.
Better to take instruction from the court. Can 2 of 2024 is an application for stay of the impugned decree. Push up. The decree impugned in the appeal is one whereby the money suit of the plaintiff stroke appellant has been dismissed. Push up next para. As such, comma, since no positive direction has been passed by the impugned decree, comma, there is no scope of stay of the decree. Full stop. Accordingly, can 2 of 2024 is dismissed on contest without any orders to cost. Full stop. Next para. In view of appearance, Mr. Bosumalik, you are appearing for all the three. Principal, secretary, please.
In that case,
in view of appearance of the respondents through their learned advocate, comma, service of notice of appeal on the respondent is dispensed with. Full stop. Next para. The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for enlistment as and when the
this
same
is a matter, legal aid matter, my lord.
Same
Kindly
is made
consider
ready for hearing.
already
Same is made ready for hearing.
already-
Legal aid matter also, appellant has to prepare the paper books and other things have to be done by the appellant. Legal aid matter does not mean responsibility shifts on the respondent.
that
At a line at Corinin,
paper
it
book
is
has already been in the record of the learned lower court, my lord.
what nonsense are you speaking, sir? This is utter nonsense.
My lord,
There's a limit to everything. And if this is the quality of representation for poor people who go to the legal aid, then we are sorry for those below poverty line people. If this is the quality of representation, just because they are having legal aid, they don't deserve people like you to represent them, who don't have minimum idea of law. You are continuing to speak without understanding the minimum of law. First of all, you have a legal aid client, you have filed a stay application in a matter where the suit has been dismissed.
not filed by me, my lord.
You are appearing, you take responsibility.
I apologize, my sir.
Next para. It is made clear that since the appellant is submitted to be appearing through the legal aid services, comma, the expenses as indicated above shall be borne by the state legal services authorities on behalf of the appellant.
Grateful.
Next. Bachara legal
I'll apologize, my lord. My unqualified apology, my lord.
Accepted, yes. 16. জোরে বলুন, আমরাও শুনতে পাচ্ছি না কথা ডাকছেন। Yes.
I'm the appellant, my lord. This is a there's a delay of 208 days. my
Appearing
lord.
for the first time.
My lord, my lord.
Serve copies of the can 1 and 2 both.
3 cans are there, my lord.
What is the third?
The application under order 41 rule 27, my lord.
The petitioners, the appellant stroke petitioners shall.
Difficulty, my lord.
না defect আছে কি?
Defect is there, my lord, for which I have tried to.
Defects have been removed.
Only one defect is not removed. What has happened, my lord?
Yes.
When it comes to the appellant numbers 1, 2, 3, and 4, my lord, their predecessor in interest was a party to the suit. He had died. He was a respondent in the suit. He had died during the pendency, not substituted.
Not substituted in the suit.
Not
You are the defendant or the plaintiffs?
He was a
You are the plaintiffs or the defendant?
Defendants.
Then you can take advantage of that, but you have to then file an the heirs have been impleted here.
Heirs have been impleted here, but they were not original parties.
But then you have to file an application. You know what? For leave to prefer appeal against.
I should have. I've tried my best to make prayers in can 3, my lord.
Can 3, let us check
Can
up.
3 prayers A and B have made.
Can 3 is order for 227.
Yes, but there are some other prayers as well.
How can this player be clubbed with order for 227?
That I bow down to your lordship. That could not have been done, and leave should have been taken at the time of
প্রথমে
filing
এটা
of
বললাম
the-
তার আগে একটা লেখে দেখো। It transpires that who died? Defendant number?
The defendant number 1 has died,
He was defendant number 1 in the suit,
my lord. Robindranath Pal,
Rabindranath Pal. So his heirs have been impleted straight away in the appeal.
my lord, as appellant numbers 1 to 4.
Acha. At the outset, comma, it is submitted by learned counsel for the appellants that the predecessor in interest of the appellant numbers 1 to 4 died during pendency of the suit, but the appellant numbers 1 to 4 were not substituted as his heirs in the suit. Full stop. Accordingly, comma, on the prayer of learned counsel for the appellants, comma, leave is granted to the appellants to file an application for leave to prefer the appeal by the appellant numbers 1 to 4. Full stop. As and when such application is filed, comma, liberty is granted to the learned advocate for the appellants to mention the same for inclusion in the list. Full stop. The appellants shall, comma, in the meantime, comma, serve copies of can 1 of 2024, comma, 2 of 2024, and can 3 of 2025 on the respondents, indicating that the applications shall be listed next on April 9, 2025, when an affidavit of service to that effect shall be filed.
And
By
I
the
was humbly praying for a shorter date. Only thing preliminary decree has
No,
been
you have to
passed.
file that other application, and unless that is allowed, we cannot allow any of these applications.
That I bow.
File it during the course of this week and mention before us before the returnable date comes.
Mine.
You have to understand that is the reason why we granted you so much time for this. File that application, mention that so that it is included with the other matters.
Number 17, I appeal for the respondent. My lord, I must admit, my lord, I'm in default, my lord. There's been a delay in filing an affidavit in opposition. It's been prepared. 3 days delay, my lord. My lord, we prepared it and
You have given a copy to them?
Yes, we already served. May I
Reply?
file-
Your Lordship, we are praying for 2 weeks' time for filing the
Why
reply.
2
Lordship.
weeks?
We had just received it on 13th March, Your Lordship.
Yes.
Kindly give us a
Very well.
fortnight's
The
time.
affidavit in opposition filed today be kept on record. Full stop. The same is accepted on condonation of delay in affirming the same. Full stop. Next para on the prayer of the appellant, comma, the time for filing. Oh, গোড়া থেকে শুরু করবো? আচ্ছা, গোড়া থেকে বলছি। The affidavit in opposition filed today be kept on record. Full stop. The same is accepted on condonation of delay in affirming the same. Full stop. Next para. On the prayer of learned counsel for the appellant, comma, the time for filing reply is extended for a fortnight from date push up the application shall next be listed on April 9, 2025 under the same heading.
Great.
Yes, sir. We'll put me later. Nelly Mandla, Hajatta Mamla listed within the court.
Your Lordship, I mean, led by Mr. Judicial is not there today due to personal reason. I was speaking for accommodation for a day.
No, that will grant you, but there are certain defects which are challenged.
The first judge's copy of the application under section 5, my lord, was misplaced from somewhere, my lord.
Great.
Mr. Ghosh had, my lord, had, my lord, made this submission before, my lord, and your lordship wanted, my lord, just a copy, my lord, to be given to your lordship. My lord,
We'll take that today
we
and we'll
prepared
grant that 1 day's time he's
But
asking.
the problem is they have issued a section 14 notice and they want to take possession tomorrow.
But
So that
tomorrow,
is-
my lord, they have to empty the flat. I'm not taking possession tomorrow. my lord.
Kojo, empty the flat.
My lord, for that. The possession is not being taken tomorrow, my lord. This much I can say on instructions.
He won't take possession, they empty the flat. Nature abhors vacuum.
That's your lordship's judgment.
Oh,
That's a part of your lordship's
I love
judgment
that
in
phrase.
the other matter.
I love that phrase because there cannot be a vacuum in law.
Yes.
Somebody has to be there. So why should they vacate then again? If you are asking for time. Section 5, what is the delay?
4 days.
We'll condone the delay and take up the application and grant an interim stay.
Third, I believe, my lord, that's for the
What is the ground for the delay?
delay, my lord. 4 days, what happened
What
was
is the ground for the delay?
Order
4
7,
days, that's
I'll tell
interesting.
your lordship, Order 7, Rule 11 was filed by them in the court below. Where, my lord, they lost in that Order 7, Rule 11 application. Then after they filed a revision application before this honorable court, there was a caveat, but we missed it by 3 days. During that period, my lord, they got a stay on the further proceedings in the suit. Now, when they got further stay, my lord, in the further proceedings in the suit,
Yes.
we went to the revisional court and we tried to move the revisional court saying that if you have granted this, my ad interim injunction, which I was enjoying, that is not being, my lord, extended. So that time, my lord, to go to the revisional court and file this, that's the, my lord, the ground for the delay.
Anyway, 4 days, allowing 4 days.
Well, then we'll move the stay application. my lord.
Stay will direct you to file opposition.
But my lord, I'm opposing why the stay, my lord, because the,
Oh, let us first condone this delay, then we'll hear. A photocopy of the application for condonation of delay is filed today, which is kept on the record and treated as the first judge's copy. Who's up next para? Since sufficient explanation for the minuscule delay of about 4 days in filing the appeal has been made out, comma, can 2 of 2024 is allowed on contest, comma, thereby condoning the delay in preferring FMAT 290 of 2024. Who's up next para? We have to formally admit it first.
Yes, ma'am. Kindly first takes up, my lord, before looking into the impugned order, takes up, my lord, page 148.
একটু দাঁড়ান শুনে নিয়ে আবার বাকি
Takes up page 148, my lord. This is the ad interim order which was granted to me, my lord, on 25th of September 2019. First ad interim order. There were, my lord, 5 extensions after this. No vacating application, nothing filed. They were contesting there. File an Order 7 Rule 11 application, obtain an order stay of all further proceedings. Court says I will
No,
not.
Order 7 ruling was rejected.
Rejected.
Against that revision from revisional court, obtained
Stay
stay.
of all further proceedings. Court says I cannot extend interim order.
That is the impugned order.
That is the impugned.
Let us see the impugned order.
Kindly have a look at the memorandum of appeal.
We'll just look into this.
Order dated, my lord, 28th of March 2024.
We'll take up the appeal as well as the application together for hearing. We're granting injunction.
my lord, but injunction or why I was opposing, my lord, because my lord, the prayer there.
আচ্ছা, let us formally admit the appeal first. Full যা বলেছি তারপর full stop দিয়ে the appeal in view of the extreme urgency, comma, the appeal is taken up for hearing under Order 41, Rule 11 of the Code of Civil Procedure. Full stop, next para. The present challenge has been preferred against the refusal by the learned trial judge to extend an interim order of injunction which was being enjoyed by the plaintiff stroke appellant all along before the trial court and was extended on several previous occasions, comma, on the sole ground that an order of stay of all further proceedings of the suit was passed by the divisional court, was granted by the divisional court in connection with the revision preferred by the respondents against an order rejecting the respondent's application under Order 7, Rule 11 of the Code of Civil Procedure. Full stop. As complex a sentence as can be. The next paragraph.
That's why your lordship had your lordship's hand on your hair.
Yes. Now, next হচ্ছে in view of an arguable question having been raised as to whether the grant of stay of all further proceedings of a suit prevents the trial court from taking up interlocutory applications is required to be decided in the appeal. Accordingly, the appeal is admitted and shall be heard on the above questions and on the other grounds taken in the memorandum of appeal. Next para. The application for stay bearing Can 1 of 2024 is now taken up for hearing. Sorry, application for injunction. বাকিটা দেওয়া আছে ফুলস্টপ নেক্সট প্যারা এবার শুনে নি এটার উপর অর্ডার yes Mr. Chatterjee, take your seat. Because you are prima facie satisfied, you have to argue against the case. Yes.
First of all, kindly comes to page 185 of the stay petition, my lord. This is the order starts at page 184. The order is issued by Order and Rule 11. My lord, at page 185, my lord, second last paragraph.
Yes.
My lord, the learned court below was pleased to hold rejecting orders and ruling on the ground that there was no averment in the plane outside the civil court jurisdiction. Because, my lord, my orders and ruling on the ground that as under Surfacy Act, the civil suit was barred, which is why I did not enter into merits. I did not file anything else because my challenge on maintenance is the first. My lord, see, in my case, my lord, in the instant case, the plaintiff being a tenant occupying the suit property for residential purpose, something like that, I do not find any averment in the plaint including the outside jurisdiction of the court by operation of provision of the Surfacy Act. One of the grounds to reject, and second, supposedly allegedly pre-mortgage tenancy. But when this order was taken up in revision, my lord, this honorable court was pleased to hold why the stay was passed, my lord, comes to page 188. Because my lord, the court was prima facie pleased to hold that the suit was barred in law because my lord, comes to the last paragraph, my lord. 1, 2, 3, 4. Fifth line from the bottom, my lord.
Paragraph 5 and 6, default in payment
my
of
lord.
rent.
So on that,
They also ask for injunction.
My lord.
They also ask for injunction in the suit, must be.
My lord. Only injunction, my lord.
The suit is for injunction.
Only injunction. And our case,
You had taken 13-4 measures before the filing of the suit.
My lord.
Then where is the alternative remedy to them?
My lord,
At this 7-11 stage, why should it be? Let us decide this revisional application also.
My lord, 17-1 is the remedy, my lord. My case was that because my lord, you have case 17-1, my lord.
It's an arguable case, but Section 17 read with the other provisions. Section 17 only
because one of the
permits someone to approach the tribunal if there is any flaw, any illegality in the measures being taken under Section 13(4).
No one. It's normal. 17(1) allows my lord, when we place.
But that is arguable. We are not on that at this point of time. We are not on the veracity of the 7-11 order.
My lord.
We are on the question as to whether this impugned order was correct. Merely because stay of all further proceedings of the suit has been granted, there are both line of judgments, one of which says that yes, it's, if it's a stay of all further proceedings of the suit, does not prevent the trial court from taking up interlocutory applications.
They have to move the interlocutory application of fresh for stay. As my lord has fallen from your lordship, there are line of judgment both sides, my lord. Because my lord,
so let us accept one of the sides and allow the.
But my lord, the interim stay, my lord, will be, my lord, affecting my service proceeding, my lord, which I have a right under the law to proceed. Because my lord, they are
by the present impugned order,
my lord,
you may have a point there.
My lord.
When the injunction application is heard on merits by the trial court, it has to be absolutely heard. Both sides have to be heard. But here, ad interim was granted, not only that, extended for 4-5 times. This impugned order only refuses extension on the sole ground there is a stay.
My lord, stay of further proceedings.
Stay of further proceedings. That, in our view, is a bad order. that's not in accordance with law. We will grant an injunction definitely. If you agree, we can take up the appeal application together and direct the trial court to take up the injunction and decide it within a limited period.
But my lord,
Subject to your having filed a written objection to the injunction. Have you filed a
no,
written?
my lord, because we having challenged the suit as a whole, not the injunction application only. The suit itself is not maintainable in light of Services Act, and that having been rejected before the divisional court, my lord.
Then we have a.
My lord, but that in
we'll
per se will also be affecting my stay order under the divisional.
We'll record your submissions on 2 counts. First, regarding the prima facie case for the present injunction. One, that stay of all further proceedings of suit prevents the court from taking up interlocutory matters also. This is first argument. Second argument, even if that is not correct, then also the suit is not prima facie maintainable, therefore no prima facie case for injunction.
My lord.
We'll deal with both and grant injunction. The application can 1 is now taken up for hearing. For hearing. Next part. Heard learned counsel for both sides. Full stop. The primary opposition to the prayer for injunction by the defendant stroke respondents is on twofold grounds. Niche Roman 1, that in view of the grant of stay of all further proceedings in the connected suit by the revisional court, the learned trial judge was justified in refusing to extend the ad interim order of injunction granted by it earlier, niche Roman 2, that the suit is prima facie not maintainable in view of the bar contemplated under the Surface Act, moreover, the outcome of the application under Order 7 Rule 11 of the court filed by the defendant's respondents is at present sub judice, due to which the appellant does not have a prima facie case for grant of injunction. Full stop. Next para. However, we are unable to agree with the respondents, at this prima facie case.
Respondent number 1, my lord.
Sorry. The respondent number 1, at this prima facie stage, on both the above counts. Full stop. Next para. Insofar as stay of all further proceedings of the title suit is concerned, we are of the prima facie opinion that interlocutory applications pending in connection with a suit does not tantamount to, within double inverted, proceedings in the suit, double inverted clause itself. Full stop. As such, the stay of all further proceedings in the suit itself, granted by the revisional court, could not be a deterrent for the learned trial judge to extend the interim order of injunction already granted and extended several times over previously. So next para. Secondly, the court, learned trial court, by the impugned order, was not adjudicating either the temporary injunction application itself at the final stage, or was considering the ad interim prayer for the first time. Full stop. The limited scope of adjudication of the learned trial judge at the time of passing of the impugned order was whether to extend the ad interim injunction order, which had already been granted upon prima facie satisfaction on an earlier occasion, and thereafter extended several times, from time to time. Full stop. In the absence of any specific recording of change of circumstances in the meantime, and stroke or any vacating application on the part of the respondent, it was beyond the jurisdiction of the learned trial judge to refuse injunction, refuse extension of the injunction order already granted. Full stop. Thus, we are of the opinion that a strong prima facie case for hearing of the present appeal on merits has been made out by the plaintiff stroke petitioner. Full stop. Next para. Insofar as the bar under the Surface Act is concerned, we are of the opinion that at least a triable issue, at least a triable, TRIABLE, issue has been made out by the appellant inasmuch as the scope of adjudication under Section 17 of the Surface Act by the tribunal is only on whether the measures taken under Section 13 within bracket 4 of the said only as to whether the measures taken under Section 13 within bracket 4 of the said act only as to whether
insofar as the bar under sections under the Surface Act is concerned, we are of the opinion that at least a triable issue has been made out by the appellant in as much as the scope of adjudication under Section 17 of the Surface Act by the tribunal is only as to whether the measures taken under Section 13 of the 4 of the said act
were tainted by any illegality and or irregularity. Full stop. Thus, comma, it is doubtful as to whether the tribunal, comma, under Section 17, comma, has the jurisdiction akin, AKIN, akin to a civil court to decide on the question of grant of injunction on the strength of title to the property. On the strength of a pre-mortgage tenancy in respect of the property. Push up next para. Thus, comma, the appellant has made out a strong prima facie case for grant of injunction. Push up accordingly, we restrain the respondents by an ad interim order of injunction from disturbing the possession and or enjoyment of the appellant in respect of the suit property in any manner whatsoever till disposal of the present application. Full stop. The respondents shall file their affidavits in opposition within 3 weeks from date, 3 weeks or 2, within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall be listed next for hearing on April 22, 2025. Full stop. You have not served on the the appellant shall, in the meantime, comma, serve a copy of Can 1 of 2024 on the respondent number 2, indicating the next returnable date, and file an affidavit of service to that effect on the returnable date.
But I was also relying on 17(4)(a) also, my lord. For the
We'll consider. Yes. And you also take instruction whether at the, if you come earlier also, you can come earlier. If you agree to the appeal application being disposed of together on the returnable date, we can dispose of the appeal application together. So either way, whichever. Well, this only revolves around your ad interim extension of injunction. So you decide on that.
All right.
Thank you. Yes, 90.
And for as per the direction,
yes,
we will file our affidavit in opposition on behalf of the respondent number 1, my lord, and serving the
just give us half a minute.
My lord, a copy has been received by us on last
Please.
Thursday.
Yes, sorry. Yes. What do you say?
Lordship, I will pray before your lordship to allow me 3 weeks for filing my reply, lordship.
3 weeks for a reply. What is the matter about?
Okay, lordship, then allow me 2 weeks only. 2 weeks.
1 week reply.
Actually, Mr. Rabindranath Mahato is appearing for the appellate.
Yes.
Actually, he will not be able to come on next week, lordship. Due to his illness,
Affidavit in opposition filed.
Mr. Bhattacharya, Falguni Bhattacharya requested me to take
Very
2
good.
weeks, lordship. He will also.
my lord, we will serve him.
Affidavit in opposition filed by the respondent number 1 today be kept on record. Full stop. On the prayer of learned counsel for the appellant, comma, the time for reply is. Are you enjoying an interim order?
Yes.
Then only a fortnight. On the prayer of the appellant, comma, the time for filing time for filing reply is extended for a fortnight from date. Push up. The application shall be listed next on April 9, 2025 under the same heading.
My lord, humble prayer is one prayer, my lord. Memo of this appeal is
Not right now. You are not entitled right now. Yes.
I am for the appellant, my lord.
What is the defect?
My lord, the defect is that the learned trial court
yes
have not passed any decree. Only judgment has been passed.
No, wrongly classified as FMAT instead of FAT. Names of parties would be verified after punishment. No. What is the impugned decree or judge? Probate. Probate is deemed decree. A decree has to be drawn up. Did you apply for drawing up of a decree?
I am the respondent at that.
In the appeal, you are the respondent.
No, I am the appellant here. I have applied before the court for providing the decree, but the learned court. And it could.
Yes, you have done it. Learned court.
Learned court said that the passed the order that it was mistakenly written decree in the judgment. The decree cannot be passed.
No. Deemed decree. Probate আপনারা decree drawn up করেন? Deemed decree. Decree drawn up করেন. At the time of call, learned counsel for the appellant hands over a photocopy of an application filed before the probate court, probate court for drawing up of decree. Which of learned counsel for the appellant submits that despite such application, the learned probate court is of the opinion that no decree need to be drawn up. We find from the impugned judgment that by virtue of the same, probate was granted, which is a deemed decree in law, and as such, we direct the learned trial judge to draw up a decree in terms of the application of the appellant within a fortnight from the date of communication of this order to the learned trial judge. Next para. Immediately upon obtaining the certified copy of such decree, the appellant shall file the same in the department, and the department shall furnish a revised report in that regard. Next para. The application is accordingly adjourned till April 21, 2025, when it will be listed next under the same heading.
My lord.
Please communicate the server copy of this order to the court below so that it can be.
My lord, in the meantime, can you please grant the stay? Because
no, we cannot, because the appeal is defective. And you have preferred an application for leave. Why? You are not a party there.
I am not the party. Because I have filed an order 32 rule 15.
First, rectify the defect. Without the decree, we cannot ascertain the names of the parties also. But communicate immediately so that within 2 weeks that is done. You apply for the certified copy and get it. As soon as you get it, file it in the department, have the revised report before the next returnable. Thank you. Next.
My lord, I am for the appellant.
Yes.
But my lord, I will go through the facts. My lord, kindly go there. What is the defects for us?
What is
it? A case, my lord. There is a railway gives sublease to the one partnership from Catix Enterprise. They have 2 partners. They included my client, the petitioner, as a third partner, and gave upon taking lots of money and directed him to run the food plaza. Now they are not paying the amount to the rail trying to evacuate the this Catix Enterprise from the food plaza. I made a civil suit in the learned court below and praying for interim injunction. Ordered to 18 July.
No,
that was rejected.
There are 3 defects. One is there is no valuation statement in your memorandum.
Right.
One, secondly, why have you classified it as FAT? It's the impugned order is an order of injunction.
I challenge that, my lord.
Challenge what?
I came before the civil revision. Normally, my lord, is when the interim injunction.
That is the ground of the delay. But what are you challenging here? Grant of injunction or refusal of injunction?
Refusal of injunction.
That is misappeal will lie. In your memorandum of appeal, you have said memorandum of appeal from original judgment. Number 2, you are not required to say those things.
My lord, right.
You are to delete whatever you have incorporated by pen and write order, original order. so that it can be classified as a FMAT. And you've also written FAT, which will be also corrected by you. 2 corrections, we will give you liberty right now. Do it right now. You just score through after memorandum of appeal from original. After that, whatever you have written, score through. Right? Just take out the memorandum in your copy. Do it right now, and just replicate that in the original. After memorandum of appeal from original, after that, whatever you have written, cut. Right? Order, original order. All right. And in the value, and after the cause title, the names, and before the preamble starts, appeal valued at why incapable of valuation. What was the valuation of the suit? You have a copy of the plaint. Plaint was valued at 99 rupees. So not incapable of valuation. Valued at, you score through that incapable of valuation and write rupees 99. These corrections you incorporate in our copies also, both the judges' copies of the memorandum. So two defects are taken care of. And another mistake, please come back to the preamble, the first page of the memo. You have written FAT.
FAT.
Yes. Score that through, and instead of FAT, write FMAT. These corrections please carry out in our copy also. Do that immediately, and there is a section 5 application also.
No, man, there is no section 5.
But there is a delay. There is a delay of 126 days.
Made a civil revision application before this court.
Automatically, it's condoned.
Directed that it will be an appealable order. It's not a liberty.
So therefore, the appeal is filed beyond time. You have to file a section 5 application.
My lord,
That will be the ground of the section 5.
Within a week, my lord, I filed it.
Huh? 126 days. Anyway, leave is granted to the learned advocate for the appellant to carry out the necessary corrections in the memorandum of appeal during the course of the day. Full stop. Next para. On the prayer of learned counsel for the appellant, the appellant is granted leave to to file an application for condonation of delay in preferring the instant appeal. Full stop. Let the matter go out of the list for the present, with liberty to the appellant to mention the application for condonation of delay, as and when filed, along with Can 1 of 2025, for inclusion in the list. Before we allow the condonation, we cannot look into we'll definitely hear you when you take up the matter next and consider that. Matter goes out of the list, file the section 5, immediately mention both, and carry out these corrections in both the judges' copies immediately. But you give your name, still you are a party.
My lord, I appear for. My lords, I appear for respondent number 3.
Yes. Acha, in the previous matter, act line add kora jato. The department shall carry out the necessary reclassification of the appeal accordingly. It a department ke bole deben je department er upor order ache.
My lords,
yes. You are appearing in 22.
21, my lords.
21, your name has been given probably. Yes. Your junior is
number
here?
3 for
Yes.
R3.
Understood. Who is in 22?
For the
Yes.
petitioner. Can you see your lordship that I have filed another application Can 2 for the listed appear?
Appearing for the first time?
No. Kindly see your lordship's order dated 10th February 2025.
Tolobon or rupees 4 not given?
That I'll definitely put in, Milord. I'll put in. So, Milord, there was a
Ductital amount of rupees such and such? No, the deposit of 8,71,276 also not made.
That is why, Milord, I have filed an application for modification. Milord, kindly, if your lordship would kind enough, Milord, my demand draft is ready, Milord, for Milord, due to financial stringency, petitioner could at best, Milord, collect, Milord, from 4 lakhs rupees from different sources, Milord, from mother-in-law, Milord, son-in-law, everybody.
This is against the money degree.
Money degree, Milord. I have, Milord, my 4 lakh demand draft is ready. I can deposit it, Milord. Time I have, Milord, trade, Milord, if your lordship would kind enough to come to my explanation at Milord can 2 from paragraph 6 onwards, Milord, page para 11, page 6, para 11, 12, Milord, these are my
This is can 2.
Can 2, Milord.
But money decree have to.
Definitely, Milord. But the
We
lordship
cannot.
kindly exercises the lordship's discretion. It's not that I
What
will not.
discretion?
I'll not deposit. I cannot.
What do you do for a living?
Milord, kindly see Milord page.
Cultivation.
Milord, yes, kindly see Milord para 11. Para 11. Milord, what happened, Milord? There was a Milord. The dispute is there was a Milord money decree against me, Milord.
You actually cultivate, or this is just for the purpose of this court?
Cultivation and Milord sales. Milord, he lives at a Beetle lives in market. Beetle lives in market. Milord, kindly see para 11. Para 11. And I have taken loan from my Milord.
You had a brick field.
Yes, the matter relates to that. What happened, Milord? In the brick field, there was an agreement between the plaintiff and the defendant that I will manufacture brick and brick and will give it to the plaintiff. Now, Milord, what happened, Milord? I have the allegation is I have prepared 4 lakhs and odd Milord bricks, but I did not give it to the plaintiff. That's why they have suffered loss and money degree. Now, Milord, this is the thing. Thereafter, Milord, the lease was the brick field by an amicable arrangement.
You took the money for the.
No, I did not take it. It is for the loss they have suffered. The plaintiffs have suffered.
Sorry, missed out.
Milord, what happened, Milord? There was a brick field, Milord.
Brick field, yes.
Yes. Milord, there was an agreement between the plaintiff and the defendant that I will, Milord, prepare bricks and will give it to the Milord plaintiff. Now, Milord, the number of bricks, Milord, which according to the plaintiff case is that I did not give that actual number of bricks, which was, Milord, I promised under the agreement. And Milord, that's why the plaintiff has suffered losses. Now, Milord, that's why this money suit has been filed. Now, in the meantime, money suit has been decreed. On the same self cause of action, a criminal case was, Milord, also filed, Milord, on the ground of forgery. And now,
Mr. Bhattacharya, have you served the copy of the application, main application?
Of service, Milord, I have served, Milord. Can one
serve a copy of this and come back? Without hearing them, we won't. Affidavit of service filed today be kept on record. Push up. We find therefrom that none appears for the respondent to oppose Can 1 of 2023 despite service. Push up Can 2 of 2025.
Another, Milord, in the order dated, Milord.
Wait. Can 2 of 2025 has been filed for modification of the order dated February 10, 2025. Push up learned counsel for the appellant submits that the condition of payment of the decretal amount as a condition for stay as incorporated in the said order be mitigated in view of the financial distress through which the petitioner is passing at present. Push up next para, the petitioner shall serve a copy of Can 2 of 2025 on the respondent as well, indicating that the matter shall be listed next along with Can 1 of 2024 on April 9, 2025 under the same heading. Yes, what is the article line at the appellant shall file an affidavit of service to that effect on the returnable date.
The 10th February 2020, Lordship has, Milord, recorded that we shall grant a stay of operation of the impugned judgment and decree. Milord, I have stated in the Milord Can 1, Milord, money execution case number 1 of 2018 is pending.
That will consider when, but come back, we'll do that.
May I deposit, Milord, this, Milord, with the learned?
No, not right now. Not right now. That's only half of them. Have to hear the other side.
Of loan, Milord, he has collected from son-in-law and Milord other relatives.
We'll consider that.
Lord, I am praying your Lordship's leave. There has been a belated application for the draw-up of your Lordship's decree. So therefore, my Lord, your Lordship's permission is required because the 7 days already been lapsed. So I am seeking for a leave.
That is for the original say. Yes, yes, leaves him. There. Ah.
My lord, I appear for the appellant, my lord.
I am responding number.
My lord had the occasion to hear the application and my lord was pleased to pass a stay of the impugned order. My lord, affidavits were directed to be exchanged. My reply.
Affidavit in opposition.
Your lordship takes the, my lord, order passed. My lord, just for a quick recap.
Yes.
Kindly takes, my lords, the order dated 6th of February 2025, passed by this honorable bench.
Yes.
My lord, the issue was very simple, my lord. By the impugned order in the suit, my lord, a notice for AGM,
yes,
which was called for, was stayed on the, my lord, application made by the defendant number 2. There were two trusts, lordship it will come back to my lord's minds. Shahu Samaj Trust, West Bengal, formed in 1981, and Shahu Samaj Trust, formed in 2018. Now, our contention was that Shahu Samaj Trust, West Bengal had a property. There were certain agendas in that, my lord, notice to be conducted in the proposed meeting. Defendant number 2, my lord, who resigned from Shahu Samaj Trust, West Bengal, was interfering with the affairs by issuing letters to the bankers of the trust so that, my lord, operation is not permitted. This prompted us to file the suit. And in the suit, my lord, defendant number 2 made an application when we issued the notice for conducting election in terms of the, my lord, rules of the, my lord, trust. There, my lord, the learned judge my lord, interfered and stayed, my lord, the operation of the notice. Against that order, I had come up when lordship was pleased to pass this order of 6th of February 2025. Now, if I just place this order, my lord, for recapitulation of the facts from paragraph 9, my lord, when your lordship is dealing can 2. Upon hearing counsel on the injunction application, the brief factual conspectus appears to be that the appellants have filed a suit for declaration that the present executive committee of the plaintiff number trust, including the other plaintiffs duly elected in the election held at the AGM of the said trust on November 10, 2019, is legal, valid and operative, and for permanent injunction restraining respondent number 2 from creating any obstruction or hindrance in any manner whatsoever in the smooth functioning of the trust and for other consequential reliefs. In connection with the suit, the respondent number 2 filed an application under section 151 of the Code of Civil Procedure seeking stay of operation of the notice dated 7 September 2024, issued on behalf of Shahu Samaj Trust West Bengal, which is the plaintiff number 1 in the suit. The moot contention of the defendant respondent number 2 is that the defendant number 2 is a member and founder trustee of Shahu Samaj Trust, which was formed in the year 1981. My lord, kindly takes a note, my lord. There is one, my lord, typographical error. It should be Shahu Samaj Trust West Bengal because 81, my lord, West Bengal was formed. The Shahu Samaj Trust West Bengal, a different juristic entity, this should be, my lord, Shahu Samaj Trust, has been formed subsequently in the year 2018 and has been operating parallelly with the other trust named above. Defendant number 2 also claims to be a trustee and portfolio holder member of Shahu Samaj Trust West Bengal. By the notice which is challenged in the application under 151 of the code, an annual general meeting was called on September 29, 2024 with primarily two agendas. First, holding an election of the said trust, and secondly, demolition of a particular building and construction of a new building at the premises mentioned therein. It is contended by the learned counsel for the respondent number 2 that the plaintiffs have no locus standi to espouse the cause of Shahu Samaj Trust West Bengal since they are not members of the said trust at all. It is submitted that in the garb of the said notice, property of Shahu Samaj Trust West Bengal, of which the respondent number 2 is also a member, is being sought to be demolished. On the contrary, appellants contend that by placing reliance on the documents annexed to the stay application, that the respondent number 2 tendered his resignation not only from his portfolio held with the Shahu Samaj Trust West Bengal, but also as an ordinary member trustee of the trust. The counsel for the appellant places reliance on the minutes of the meeting. My lord, I had shown the minutes of the meeting to show that this resignation was also accepted by the same gentleman, respondent number 2, who was present in that meeting. Counsel for the appellant places reliance on the minutes of the meeting dated 19 September 2018 of the West Bengal Trust, which is annexed at page 89 of the stay application, as well as a notice of resignation issued purportedly by respondent number 2 on September 19, 2018, annexed at page 88 of the stay application. It is further submitted that apart from the respondent number 2 have no locus standi to espouse the cause of the plaintiff number 1, in the absence of any allegation regarding any irregularity in issuing the impugned notice, prayer sought in the application under section 151 of the court could not have been granted, more so since it is beyond the scope of the suit itself. Learned counsel for the appellants takes us through the averments in the application of the respondent number 1 under section 151 of the code, where it has virtually been admitted that the property in dispute belongs to the Shahu Samaj Trust West Bengal, which is the appellant number 1, as well as the represented by the other appellants. Hence, it is submitted impugned order to be set aside. We find strong prima facie case for grant of interim protection to the appellants has been made out. First, although there may be some doubt as to whether the notice of resignation dated 19 September 2018 was in respect of the West Bengal Trust being addressed to the chairman of Shahu Samaj Trust Simpliciter, there is sufficient prima facie evidence to show from the minutes dated 19 September 2018 that the respondent number 2 had tendered his resignation, more so since his signature also appears as item number 28 of the said minutes, although such signature is disputed by the counsel for the respondent number 2. That apart, we find from Annexure F at page 99 of the stay application that the present functionaries who are also plaintiffs in the suit were elected as portfolio holders in Shahu Samaj Trust West Bengal, that is the plaintiff number 1. Moreover, in the application under section 151 of the code filed by the respondent number 2 himself, it has been admitted that the trustees of the Shahu Samaj Trust are trying to sell and to develop the trust property of Shahu Samaj Trust West Bengal, which is the plaintiff number 1 in the suit. Hence, since the plaintiffs espouse the cause of Shahu Samaj Trust West Bengal in the plaint and have furnished sufficient prima facie material to vindicate their stand as portfolio holders and trustees, having locus standi to file the suit in respect of West Bengal Trust, the respondent number 2 has clearly admitted that Shahu Samaj Trust does not have any interest or title to the property in question. Now, I will show from their affidavit in opposition, a complete contrary stand has now been taken in the opposition. That apart, no specific illegality in issuance of the impugned notice dated 7 September 2024 having been made out in the section 151 application, we do not find any reason for the learned trial judge to have granted a blanket stay of operation of the said notice. Moreover, the other component of the said notice, that is demolition of the building in question, is merely a part of the agenda of the said notice, and it would be premature at this stage to stay the notice itself before any decision of demolition is actually taken in the annual general meeting held pursuant to the said notice. Hence, apart from being premature, the impugned order suffers from the lacuna that the prayers made in the application under 151 of the code are somewhat beyond the purview of the suit. In such view of the matter, therefore, Lordships held that there is a prima facie view and prima facie case in favor of grant of stay of operation, and Lordships had stayed the operation of the impugned order. Now, my lord kindly takes the petition. My lord, 2 documents for a quick recapitulation. The resignation letter, because I have to meet this point that this resignation is in respect of Shahu Samaj Trust West Bengal, and the fact that it is accepted by the respondent number 2. My lord kindly comes to page 88, which according to me is the resignation letter signed by the respondent number 2. Of the application, my lord, page 88. My lord, this is dated 19 September 2018. It's addressed to Sriman Adhyaksh Mahoday, Shahu Samaj Trust, Kolkata. Then there is the word Paschim Bengal. So, my lord, a doubt was created or is sought to be created that whether this is actually my resignation, as in respondent number 2's resignation, in respect of Shahu Samaj Trust West Bengal or not. Now, my lord,
No, but it's written Shahu Samaj Trust, Kolkata, Paschim Bengal.
Kolkata, Paschim Bengal.
That may be
now,
the address of Shahu Samaj Trust.
Maybe. My contention is, yes, the moment it is Paschim Bengal, it relates to my lord, the 1981.
If Paschim Bengal was juxtaposed with Shahu Samaj Trust in the line above, then we could have understood.
1981
then it would have been
without any doubt.
Full proof.
Yes. But even otherwise, I am trying to, my lord, persuade your lordships to hold in my favor again by, my lord, showing the minutes where he is not only present, but he signs where the acceptance is done.
That was in our order also.
Yes, lordship had
apart from this,
that, because lordship had, my lord, prima facie held that maybe it is not his resignation, but because of the subsequent fact, it is clear that he resigned from that Shahu Samaj Trust West Bengal. This, my lord, lordship will find at page, my lord, it starts at 89 in Hindi typed copy.
Yes.
It is dated 19 September 2018, my lord, at the top. आज दिनांक 19 September 2018. Lordship will
Yes.
find that.
Yes.
शाम 5 बजे P89 CIT रोड कोलकाता 54 में साहू समाज ट्रस्ट पश्चिम बंगाल की विशिष्ट सभा की गई, जिसके सभापति श्री राजेंद्र प्रसाद साहू जी ने किया. So my lord, this meeting was in respect of Sahu Samaj Trust West Bengal. Now my lord, same page 89, my lord, the 5th paragraph. Thakur Prasad Gupta ji ne.
That is respondent number 2.
That is respondent number 2. Possibly lordship has a marking there.
Yes.
ठाकुर प्रसाद गुप्ता जी ने आकर साहू समाज ट्रस्ट के उपाध्यक्ष पद एवं ट्रस्ट की सदस्यता से त्यागपत्र दिए. उन्होंने स्वयं त्यागपत्र लिखा एवं अध्यक्ष को दिया एवं कई उपस्थित ट्रस्टियों ने भी विटनेस के रूप में दस्तखत किया. Now my lord kindly comes to page 92. Third line. ठाकुर प्रसाद गुप्ता जी ने कहा कि उन्होंने त्यागपत्र दे दिया है. ट्रस्ट के द्वारा ठाकुर प्रसाद गुप्ता का साहू समाज ट्रस्ट पश्चिम बंगाल के उपाध्यक्ष पद से एवं ट्रस्टी सदस्यता दैट इज मेंबरशिप से त्यागपत्र दिया है, उसे स्वीकृत किया गया. So this is acceptance of the resignation discussed in the meeting where he was also present. My lord, his signature lordship will find at, my lord, the resolution book is annexed, page 93.
28.
Yes, 28, serial number 28. Now, my lord, apropos this, my lord kindly takes the opposition once and comes straight away to page 84. Because my lord, respondent number 2 in the opposition is trying to give an impression that I had not resigned from Paschim Bengal, Sahu Samaj Trust Paschim Bengal. My lord takes 84. And I'll show from this document that this contention is incorrect and the falsity of the stand. It is, my lord, apparently, my lord, a document of Sahu Samaj Trust West Bengal at page 84.
What was the date of that previous one?
My lord, that was September
19th.
September 2018. Lordship sees the date 8th of November 2018. So subsequent to that, Sahu 8 November 2019.
Yes.
Sahu Samaj Trust West Bengal is written at the top. My lord kindly comes to the first Roman 1. Following was discussed and decided to act upon. Immediate registration of our trust must be done with the Registrar of Assurance West Bengal. This is, my lord, telltale. Why I say this? 1981, it's already registered. This is the case which they have come up with in their written statement. The written statement is annexed. I only show one paragraph.
They have admitted that this was West Bengal was
Registered in 1981 in their written statement. Kindly takes, my lord, page 91 of the AO. Same, 91 of the. My lord, this is subparagraph A of paragraph 6.
Yes.
One trust deed was registered and executed on 25th September 1981 before the Registrar of Assurances, Calcutta. Vide book number such and such, volume such and such, page so and so. So there was no, my lord, reason for holding any meeting for the purpose of any discussion regarding registration of this trust with the Registrar of Assurance.
Yes.
Now, my lord, kindly sees Roman 4.
Yes.
Voting for electing new committee of Sahu Samaj Trust West Bengal for next term was completed by show of hand in the House, and following are the new elected committee. My lord, he has admitted that after 2011, he was never elected. My lord, this is also my case. And my lord, the document which I had annexed to the stay application of 2019, that shows, my lord, who are the current office bearers. My lord remembers, my lord, when I had, my lord, moved the application, I had also, my lord, taken your lordship through the constitution of the trust, the deed, and the provisions, which said that for 2 years, it can continue, the office bearers, additional 1 year term. Thereafter, my lord, it has to be done. There was, my lord, a gap for a long time.
and an application under the my lord, Charitable and Religious Endowments Act was made before this court, when my lord, under the aegis of a special officer, a committee was formed. Thereafter, with passage of time, my lord, in 19 we were, my lord, the office bearers were elected. Now during COVID, they could not take steps further, but the agenda which was one of the agenda which was the subject matter of the notice challenged by way of that 151 application was, my lord, to hold election for the purpose of, my lord, appointing new office bearers. So anybody who is a member who is otherwise entitled to participate for the purpose of holding an office in the Shahu Samaj Trust, West Bengal, could have participated if the meeting had happened. But because of that order, my lord, which has now been stayed by your lordship, we have not taken further steps after your lordship's order also. So, my lord, this fact that his re-election, which is being discussed again in 8th of November 2019, is also incorrect because of the document which we have disclosed at page 99, my lord, kindly comes of our application, stay application. Because if I succeed in establishing that he was no longer a member, he resigned, and he was no longer an office bearer also, then, my lord, this minutes, which I am now relying upon at page 99, it records the appointment of the new office bearers, which lordship will find at page 100. At page 100. My lord, kindly takes C. C is, my lord, Secretary Sri Surendra B. Dhote proposed the name of Rajendra Prasad Shaw for the post of secretary, and Sri Radharasham Shaw seconded the proposal. By unanimous vote of the trustees present, Rajendra Prasad Shaw was elected as secretary. Similarly, in A, my lord, Shambhu Prasad Gupta was elected as chairman, and B, Indradev Gupta was elected as the vice chairman. Now, I can also show from his affidavit, my lord, his admission, paragraph 10, my lord, at page 11 of his opposition, my lord. Kindly takes page 11, paragraph 10 of apropos this issue, my lord.
Page?
Page, my lord, 11, paragraph 10 of the opposition.
Oh, yes, right.
My lord, the fourth line of that paragraph, in this connection, I state, though I have not elected any post of office bearers, but I was and am continuing as an ordinary trustee of the said trust. My trusteeing is lifetime. This is his case, my lord, in the opposition. And he is dealing with paragraph 3, subpara 3 of my application. Just for the sake of completion, my lord. My lord, sorry.
Yeah.
Well, just for the sake of completion, I will just read it for your lordship. Paragraph 3, subpara 3 is at page 4 of my application. I have stated, in terms of the order dated 22nd December 2010, a meeting of the trust was held on 12th March 2011 under the supervision of the special officer, and new office bearers of the said trust were elected. Pertinently, the respondent number 2 was the chairman of the said trust at the time of formation of the same. However, he has not been elected as an office bearer in the said elections, as well as in any subsequent election of the said trust in which the respondent number 2 had participated. This is evinced from inter alia minutes of the meeting held on so and so. And to this, my lord, his stand is in paragraph 10. Therefore, my lord, two things emerge. One is from the document at page 99, read with 103, my lord. Resignation, he cannot today deny that he resigned. He is no longer an office bearer of the trust. And I corroborate this from the fact that paragraph 10 of his opposition, he has admitted this position. Second, my lord, the document he wishes to rely upon to show or to try and persuade the bench that I still continued after that resignation as an office bearer of Shahu Samaj Trust, West Bengal. That document, the genuineness of the document is, my lord, in doubt. Because of the first and fourth, my lord, the sentences or the, my lord, recordings there. Now, he also takes a point in the opposition that we don't, the appellants, plaintiffs have no locus and we are strangers. My lord, to address that, my lord, I showed the document the minute after, my lord, at page 99, the minutes of the general meeting of the trustees, 10th of November 2019, which appointed, my lord, the office bearers. The names of the present office bearers who are, my lord, the appellant number 2 and 3 before your lordship are Indradev Gupta and Rajendra Prasad Shaw. Lordship will find their name at page 100, B and C, as the, my lord, vice chairman and the, my lord, elected secretary of the trust. So that locus point which he has taken also, my lord, cannot stand. My lord, then, my lord, he refers to a tax bill in his opposition. My lord kindly takes the tax bill, which is at page 72 of the, my lord, opposition. This is a 2016 document. At the top, lordship will find the date, right-hand corner, 3rd of December 2016.
Yes.
So prior to his resignation. Even otherwise, my lord, I will show from the averment, kindly comes to, my lord, paragraph 3F at page 7 of the opposition. It is also mentioned herewith that since the purchase of the trust property situated at SN Banerjee Road, Kolkata, by virtue of the trust deed which was executed on 25th September, it should have been September 1981, the defendant opposite party number 1 paying property tax to Kolkata Municipal Corporation. The document, my lord, itself does not show that opposite party number 2 or respondent number 2 is paying tax. It is a property tax bill in the name of, my lord, the trust. My lord, the document at page 72, if your lordship sees, it does not, my lord, anyway, my lord, reflect that, my lord, the payment is being made by the opposite party number 2. On the contrary, the owner's name is there, Shahu Samaj Trust, West Bengal, and the premises number is there. So this also, my lord, cannot be evidence of the fact that he is, my lord, a person who is controlling Shahu Samaj Trust, West
Probably
Bengal.
he tries to say that it has come from his custody. So
But that will be only in respect of the document, my lord, is originating from or is in respect of the trust. Not, had it been, my lord, a payment receipt issued in the name of the defendant number 2, which said or which acknowledged, my lord, receipt of payment
so
on
he's in
behalf of the
custody of the
trust.
bill. He says that he is depositing on behalf of the trust.
But that was, my lord, prior to his resignation, even otherwise, because this is 2016. My resignation, which I am referring to, my lord, is of 2018, 19th of September 2018.
Yes.
So thereafter, my lord, there is no document. And the only document he seeks to rely upon, the one which I just now showed, my lord, where he says registration is required. Apart from that, there are similar documents post that, my lord, document at page 88. My lord, lordship, I had shown page 84, which is the document of 8 November 2019.
Yes.
He also showed, my lord, has relied upon other documents starting from page 85 to show that on 29th February 2020, there is a meeting, and again at page 86, 20th March 2022, there is a meeting.
Yes.
But, my lord, for the same reasons, I say, my lord, these are all documents which, according to me, are, my lord, doubtful. They do not, my lord, inspire confidence. My lord, if I look at it with the surrounding facts, and, my lord, the pleadings, not only in the written statement as well as in the opposition. My lord, the last point which I want to argue is, my lord, that notice, which was the subject matter of that 151 application, if lordship kindly takes that notice, page 121 of the application, my lord, this injunction application.
Yes.
My lord, this is 7th of September 2024. Notice is given to all members of the trust that a AGM of Shahu Samaj Trust, West Bengal shall be held. My lord, this is only saying that in a proposed meeting, these agendas would be voted for or against. And whoever are members of the trust can participate. My lord, I fail to understand what prompted my learned friend's client to, my lord, apply under 151 in my suit, where the reliefs are completely different, and, my lord, seek stay of this notice. I had shown, my lord, the reliefs claimed in the plaint,
if Lordship kindly comes back once, my lord, at 116, my lord, what is the relief I had claimed in the suit, and whether this sort of a prayer in the 151 application can be maintained apropos this relief in the suit. My lord, 116, the relief start. Declaration that the present executive committee of the trust duly elected in the election held at AGM of the said trust on 10th November is legal, valid and operative. Permanent injunction restraining defendant number 2 from creating any obstruction in the smooth functioning of the trust. My lord, the permanent injunction which I am seeking, my lord, this stay of the imputed notice is really, my lord, giving a leverage to, my lord, that party who is, according to us, my lord, is no longer an office bearer or even a member of the trust.
Yes.
And 151 application, the prayer which was made, that is at page 127. Pass an order thereby stay of operation of the notice dated 7 September 2024 being annexure A by such and such. A notice which is not even the subject matter of the suit. My lord, reliefs not pertaining to this notice. My lord, the learned judge had, my lord, passed an order, blanket order of stay, as your lordships had recorded in the first order. And kindly takes, my lord, paragraph 6 of this application also at page 123. The same averment which is there in the written statement regarding the registration of the trust with the registrar of assurances.
Yes.
One more paragraph. I did not understand, my lord, why this averment is there. But if your lordship comes to, my lord, subpara G of paragraph, my lord, 6 at page, my lord, 7. Subpara G of para 3 at page 7 of the opposition, my lord.
Yes.
When the defendant stroke opposite party number 2 observed that the trustees of Shahu Samaj Trust, which was executed on 21st February 2018 with ulterior motive trying to grab the immovable and movable asset of Shahu Samaj Trust, West Bengal, and also when defendant number 2 observed that trustees already changed
This is
the
in
letter.
consonance with the section 151, which was discussed in our order also.
Because lordship had, my lord,
This was one of the grounds of.
yes, and lordship also made an observation because it was absolutely contrary. And I am nowhere, my lord, related to Shahu Samaj Trust of 2018. I am trying to protect as the office bearer of Shahu Samaj Trust, West Bengal, which was formed and registered in 1981. That has a property at SN Banerjee Road. We are trying to preserve that property for the purpose of the members of the Shahu Samaj. For that purpose, my lord, and I don't have any personal interest here because the court had initially in 2010, my lord, said under the special officer meeting would be held, office bearers. The trust did itself, my lord, postulates the manner in which the office bearers would change hands. And
When this allegation is against the Shahu Samaj Trust, of which he's a member.
I am not.
Not. Right.
So this, my lord, pleading, I really did not understand why this was there.
Yes.
My lord also takes, my lord, page, the same paragraph, continuation. And also when the defendant number 2 observed that the trustees already changed letterhead from Shahu Samaj Trust to Shahu Samaj Trust, West Bengal without the consent and permission of trustees of West Bengal, defendant opposite party number 2 then and there with protest tendered his resignation by a letter dated 31st July 2018 from the post of vice chairman only from the trust which was executed in 2018. As if the trust which was created by him 2018, he resigned from that trust when he realized that members of that trust or office bearers of that 2018 trust are trying to deal with the properties of the 1981 trust. It's a bit confusing, my lord, but I really don't understand why this was, my lord.
No, to portray that the resignation was from Shahu Samaj, not West Bengal.
That can be one reason. He also says that that resignation letter has been tampered, the one which I am showing, my lord.
He says only from the trust. Which trust he does
So
not
later he has also said in another paragraph, I'll show that para also, my lord. Paragraph
Shahu Samaj.
West Bengal, my lord, kindly comes to paragraph 11 of the reply at page 13.
Reply?
I'm sorry, my lord, the opposition at page 13, paragraph 11.
Yes.
Third line, in the context that I state that from the very beginning, when I realized that after execution of the new trust, that is Shahu Samaj Trust, which was executed on 21st February 18, the present newly formed executive committee of Shahu Samaj Trust was trying to grab the immovable assets. Fixed deposit, big money deposited by respondent number 2 in Allahabad Bank, now Indian Bank, and landed property at SN Banerjee Road. Then and there tendered his resignation from the post of vice president, not for the post of trusteeship in respect of newly formed Shahu Samaj Trust 2018. Plaintiff motivately and ulterior motive suppressed the fact that I tendered my resignation in connection with Shahu Samaj Trust, not Shahu Samaj Trust West Bengal. Then he annexes last, my lord, penultimate subparagraph of that paragraph. I further state, or just before that, it is unfortunate on the part of the plaintiff that by manipulation and manufactured my resignation letter by typewriting and the word West Bengal, which is contrary to my original handwriting letter. I state that for adding the word West Bengal, the Honorable Court was I think it's a typographical misleaded or something, my lord, he wanted to say. The acts of the plaintiff is illegal. But he does not, my lord, say anything.
Mispleaded. Wrong pleading was made before the court.
My lord, he does not, my lord, say anything or
But
take
is
a
that
stand.
resignation letter which he has annexed?
Yes.
Because he has annexed a resignation letter.
That is there, my lord, 31st of July. That is page 73 of the opposition.
And you have also annexed a resignation letter in your application.
The one which I showed, my lord, initially.
The page number was?
That is at page 88. My lord, 88 cannot be compared with 73 because 88 is according to us Shahu Samaj Trust West Bengal. 73 he is saying of Shahu Samaj Trust of the 2018 trust. So possibly what Lordship just now indicated, he is trying to, my lord, create an impression that I resigned from 2018 trust, not from 81 trust. Now, my lord, kindly comes to page 76.
So we had some doubts about that also.
Lordship had recorded that also.
We have recorded in the order also. There is some doubt regarding your resignation letter. His but the next minutes, yes.
And that is not, my lord, explained here. That I was not present, my signature is not there. And that minute or that meeting was in respect of Shahu Samaj Trust West Bengal. Now, I must also show, my lord, page 76 of the reply of the opposition. Page 76 of the opposition. According to my learned friend, my lord, this is the letter which was the resignation letter in Hindi, which was issued to Shahu Samaj Trust. No, the expression Paschim Bengal, which I showed from page 88,
not there.
Is not there in page 76, and therefore, according to my learned friend, page 88 is something which has been possibly manipulated. This is what he is trying to say, my lord. To that, my lord, I say I have not seen the original of this document. This has come for the first time here in the opposition.
You
And
have come up against an ad
the date,
interim,
lordship, is the
ad
date.
interim refusal. You have come up against an ad interim grant of injunction.
Yes.
Oh, sorry, that was
151,
stay of the notice.
Stay of the notice.
151 was allowed.
151.
Not ad interim, it was allowed.
I'll just confirm.
Just check up the impugn order. Yes, allowed. Allowed on contest.
Yes, final order, my lord. Application is allowed on contest without cost.
Yes.
So, my lord, this date, lordship kindly takes note of the date at page 76. I could not understand what is this date.
এটা কত হিন্দিতে এই নাম্বারটা কত 19/9/18 19th September 2018. That is the date.
I'm sorry, my lord.
19th September 2018. The same date as your
Then it
page 88.
19. I can't read
No,
numerical.
Justice Kumar is there. So
My lordship is absolutely then correct. So this is, my lord, what he is trying to, my lord, portray, or he will try to argue by, my lord, relying on this document. But if your lordships, my lord, look at it with the, my lord, surrounding events, surrounding documents, and the stand taken in the affidavit as well as in the written statement, my lord, I say that this gentleman had resigned from this post, and there is, my lord, no protest if he had been the office bearer since, my lord, 2018, and that resignation letter which I am relying upon, or that minutes of the meeting is a forged document, there would have been some protest from 2018 to 2024. These are my submissions, my lord.
yes, let us hear the other side. Yes, sir. What is your?
Page 76 of my affidavit. And page 88 of their application on a tally this one.
Right. Yes.
Here, originally, there is no West Bengal.
No.
Page 76.
No West Bengal.
But typewriting.
Even the typewriting, we have some doubts. We had some doubts when we passed the ad interim order.
Manufactured documents.
No, even if it was genuine, then it says House how much trust. It stops there, not House how much trust Paschim Bengal.
There are two trusts. One executed
with and without
in
Paschim Bengal.
1981. That is Sahu Samaj Trust, West Bengal.
Yes.
Another was executed 2018. Only Sahu Samaj Trust. I resigned from my post from the trust of Sahu Samaj Trust, not West Bengal.
That is your case.
They manipulated by typewriting West Bengal. This document, my lord.
But what about page 89 of their application? That minutes which are signed by.
I am coming.
Yes.
These documents is filed by the plaintiffs before the citizen court. Cannot deny it. First, my lord, I state by suppression of material facts, they filed the suit before that and also filed this application by suppression of facts. Plaintiff number 3. Up to 2018, there was no in picture. No in picture, but I'll kindly see the plane. Kindly see the NS plane. Plaintiff, what? Plaintiff, plaintiff.
Yes, plaintiff. Page 108.
Please. And kindly see page 113. 113. 112. 112. Para 10.
Yes.
That from the records and documents of the said trust, it is clear that defendant number 2 was the chairman of the said trust at time of formation of the said trust, but subsequently he was not elected as chairman of the said trust in the election held under conducted by the special officer appointed by the Honorable High Court at Calcutta in 2011. And now he is continuing. He admitted in the plain, he is continuing as an ordinary trustee of the said trust. Next para. In this context, it will not be out of place to mention that in the election held under the supervision of the special appointed by the Honorable High Court at Calcutta, the said defendant number 2 was the candidate contesting for the post of secretary. However, he lost in the said election and his place, Rajendra Prasad Saw, elected as secretary. My lord, kindly see page 86. Of their document. 86. 1, 2, paragraph 3. Tomhu Prasad Gupta is therefore elected as the secretary of the Sahu Samaj Trust. But from the very beginning, by suppression of facts, they adopted this plain and another application. Thereafter, my lord, kindly see page 115. Para 19.
Yes.
That the plaintiff state and submit that the defendant number 2 since the year 2011 is not contesting for any post in the aforesaid trust and save and accept the ordinary membership of the said trust. But now he is saying, no, he has no membership. His membership. But they are available. He is continuing his trusteeship. Being being an ordinary member of the said trust is not entitled to create any obstruction in any manner. 19, last pen. My lord, the plaintiff number 3, plaintiff number 3, up to the year 2018, he has no entity. When he came, my lord, kindly, my lord, yes. Second task sheet. Kindly second task sheet. Page 40.
Page 40
of their mine. Opposition.
Yes.
Page 40, the new trust. They have suppressed this trust. They have suppressed from the very beginning. My lord. Page 42.
Oh, they say that they are not Members of
Rajendra Prasad Sao. He came to the picture. Before that, he was a stranger. But he is claiming that he is the secretary. See, he elected as secretary in presence of the special officer. Kindly.
No, this is against their submission that they are nobodies in Sahu Samaj. But they are shown to be a member.
From
Trustee.
the very beginning, I am stating that I was a founder member in this new. I was the founder member.
Yes, you were there.
Founder member. In the year 1981, I was the founder member. Both the trust I was the founder. When I created this trust, they are the trustees. Rajendra Prasad came to a picture. Then and there, he is trying to grab the property of the Sahu Samaj Trust, West Bengal. And to grab the property, bank account, which was deposited in connection of the Sahu Samaj Trust, West Bengal. This new year, there was no property, no bank account. Only 20,000 amount was created. My lord, yes, another thing. Kindly observe their conducts and kindly see page 77. Page 77.
Of what?
Of my opposition.
Yes.
This is the order of the London City Civil Court when he moved order and application order 39, rule 1 and 2. My lord, page 83. What was the direction of the London Trial Court in regard operation of the banking transaction? Under the aforesaid premises, the defendant number 2 is hereby prevented from causing any hindrance in operation of the bank account of South Samaj Trust lying with the bank of defendant number 1 for a limited period till hearing the defendant of this suit with a condition upon the plaintiff to act in terms of clauses of the trust deed as pointed hearing before, with a specific direction upon the plaintiff only to incur the essential and urgent cost of discharging the urgent functionaries of the trustee from the bank account till the period of 8/7/2028, with a further direction to submit before this court the document of banking.
Sir, once we decide this application, what remains in the appeal?
No.
If you both of you agree, then we can treat this hearing to be the hearing of the appeal. Because suppose we decide this the application.
In the meantime, my lord, I have no objection. In the meantime, my lord, only protect the trust property and the bank account.
No, but our limited jurisdiction is regarding this.
They already encashed a big amount.
No.
From the bank.
We can treat today's
By
hearing.
violating
We
the-
can treat today's hearing also as the hearing of the, because what you are arguing, both of you, pertains to the appeal itself.
Protect the only
protect or not will decide upon hearing the appeal.
Protect the trust property. It is my lord's duty. Trust property they cannot destroy. They cannot sell.
No, but this present appeal is not in connection with protection of the trust property. You have asked for that election notice to be stayed. I mean, this does not pertain to the trust property at all. And regarding that demolition, we have held that no,
Sell the property.
you have not asked for an injunction regarding that. You have only asked for stay of. We are hearing an appeal
That
against a
means-
limited.
That means if they stay the notice, that means the property was protected.
Property will be protected. Notice has been issued by them for holding an AGM to hold an election. So how does that pertain even to protection of the property of the trust?
My lord,
We are
my lord,
hearing
my
only
lord,
an
if
appeal
the stay-
against that.
My lord, if the stay of the operation of the order of the London Judicial Court,
Then they will hold
they
an
can
election.
they can easily conduct the sale.
That has nothing to do with the sale. Even today they can conduct a sale, even if we did not stay that order. You have asked for stay of a notice by which they have asked for a. They are trying to fix a date of
Upon
election.
this,
They are the
and-
present portfolio holders. They can even today sell it.
They are portfolio holder of the Sahu Soma Trust.
Sir, right, you are
not
not
the
understanding.
town
We are
of
not being able to make you understand. The entire scope of this appeal is in respect of an order which they have challenged. By that order, you have obtained for a stay
Date be fixed.
of a notice.
My lord, date be fixed. Only my
Date
submission.
for what? We are hearing
What
the appeal. That is,
hearing.
we are saying that can we treat this hearing as a hearing of the appeal itself along with the application? That is what we are asking you. Then we are hearing the appeal
I am
itself.
showing their conduct. By violating the court's order. They direct.
Are we hearing the appeal itself now? That is what we are asking you. If you agree, then we will.
I only want, my lord, to protect us. Trust property. This is my. That will decide.
We have a 1 point question. Are we hearing the appeal or the stay application? If you agree, then we can treat this as an appeal.
Firstly, stay application.
So we are hearing the
then
stay
appeal.
application. Obviously, first stay, then appeal, we also know that. But now we are, because the stay application is fixed. If you agree, we will treat this to be the hearing of the appeal and conclude the hearing of the appeal itself.
I have not.
So can we record that we are hearing the appeal on consent and Mr. Datta also has to agree?
I am agreeable, my lord.
Mr. Rai, if you don't agree, we won't. We are taking up only the application.
No, I agree, my lord, because we have, my lord,
If
taken
you
back
agree,
the-
then Mr. Roy will not agree.
No, he also says he agrees.
He's not sure. Take instruction, Mr. Rai, whether we can treat this as the hearing of the appeal, because we
the
are
same
wasting
time
so much.
would be invested to hear again the appeal.
Again the appeal, again the
Yes.
same thing. So this is the একটা order record করতো প্রথমেই পরে ভুলে যাওয়ার আগে যে on consent of the parties the hearing of the appeal itself along with the application is taking up by dispensing with formal preparation of paper books and calling for the records. Please continue. We are doing that. Please continue.
Without trial, my lord, this issue will not be solved.
Exactly.
Trial of it.
Exactly.
This is necessary, my lord. Without trial in evidence, this problem will not be solved. Only my prayer, my humble prayer, my lord, to protect the trust property. It is my humble prayer.
Mr. Rai, how do you explain page 89 of this stay application? Let us come back to that question. Page 89 of this stay application, that minutes. Where your resignation was accepted. Even if you give a go-by to that false letter of theirs, false letter of resignation, even if you give a go-by to that, these minutes are there. It seems to be genuine because it records your anger also.
My lord, I show you. The minutes are manufactured documents. Same day, 2 minutes. Same day, 2 minutes.
Where is the other minute?
On page 93.
Ninety-three. 93 is the last.
Yes.
Yes, 93 is the last page recording the signatures of the persons present in the meeting.
This is only single paper.
This is a continuation of the meeting.
No, my lord, 94, page 94.
Oh.
This is the signature.
Continuation. 31, 32,
I have not any signature in this matter. Only this is the only one paper he said. This is the minutes when I was not present. There is no my signature. This is also the forged document, manufactured document. Only this paper, the NS, and I was present in the meeting. No. 94. There is 9 members' signature.
But this then page 93 cannot relate to 94 if there were 9 members only.
I don't know where he collected this paper. This is only single paper. This only single paper. All matters are confusing. They are violating the Judicial Court's order, encash the big amount, not submitting any document.
That you can always take out an application for contempt there.
No.
39(2)(a) can always be filed there. You can do that. That is beyond the scope of this. These are bare allegations. These are beyond our pleadings. These are not before us. How can we accept your contention on that?
Any decorum, any post order.
That is your allegation. That is not on record. You have not even filed any order 39 rule 2A. So anything else, Mr. Rai? Yes, Mr. Datta. How do you explain this second meeting at page 94? You are hearing him now in reply? Yes.
At page 95.
94 of your application. Take a seat, Mr. Rai. You finished. And the paper on which he has signed, that tallies more with the with page 94 onwards than your, because your previous pages just in blank paper, it's a typewritten copy, no short signature, nothing, no indication that it was in some sort of a book, just a printed a bunch of printed papers. You could get this printed today itself from somewhere. But rather the page 93 has an official look, but you see the next, what is the next meeting resolution? 94 you did not place before us.
No.
For obvious reasons, because neither you nor I could read.
93 to 98.
Yes, what are these?
Well, this was the 19 September 2018.
Same
I
date.
understood it to be the 19 September 2018 resolution.
Yes, but it's fishy because same date.
Because the number of persons present in 94 is
Different.
not matching with number of persons in
Not,
93.
not matching.
And my learned friend is there, correct?
No, but Mr. Doctor, probably this is a transcript. Page 89 to
no,
yes.
Page 89 to 92 is a transcript.
Yes, it is a transcript of page 94 onwards. It is a page, yes, it is. Right. Let us see 1 to 3 tallies. After that,
my lord can read page 94, the first paragraph. I cannot
yes,
read.
yes.
Sri Rajendra Prasad, it starts with this. Sri Rajendra Prasad.
If you tally with the previous page 89, then you can read. I am reading page 89.
Oh, yes.
Now you read with that page.
Yes.
It is the transcript of that. Yes. And Thakur Prasad Gupta and all. So if this be a transcript, then the signatures are contained there in that page only, page 94. Where do you get page 93? Or it could be that,
my lord, honestly speaking, I just
utterly confused.
No, I discovered this now only. If Lordship permits me, I can seek an explanation on this. Of course, I have to satisfy your Lordship's conscience on this document.
Yes, because otherwise.
No, otherwise an impression is, my lord, even I am carrying an impression that whether this 93 page is actually a continuation of 94.
Yes, right. Just come out of the blue.
No, I will, my lord, since my lord, this question has come up, I will definitely seek an instruction on this part, and I will, my lord, apprise your lordships, my lord, on this. I don't want your lordships to, my lord, carry an impression that something has been, my lord, slipped into
No,
this.
if we carry that impression, it will be
I will
risky
try
for
and
you.
dispel that. I'll try and dispel that. I'm asking for
You
an
cannot
opportunity.
take the risk of us carrying that impression.
If
Because
this
you are
is-
the appellant
my lord,
here.
if this is wrong, then I will come.
No, no, that
I
we
will
know.
come and, my lord,
That
concede.
we know, Mr. Dotto. Before you say, either Mr. Roy, either
noticed it.
any of them or any of you, if you find out that any of your submissions is wrong or your client is on the wrong side,
I will
you will
definitely,
be
my
the
lord.
first persons, both of you, both sides. You will be the first persons who point out to us. That we are confident of. But we are, for the present, we are very confident. This seems to be a transcript, page 90.
Lordship is correct. 94 to that.
Yes,
my lord,
yes, it's
the
a
rest of
transcript.
that, my lord.
But then the
4 page
signatures become haywire. I mean, where does page 93 coming from?
Because I was relying on this document to show his presence in the meeting.
Yes, but then if you take page 94 and if you see the list of names of members present and all, the format is similar to 93. But 93 then does not, it's a mismatch. Because
And
if
also, my lord, see whether, my lord, the names appearing in serial 1 to 9 at page 94 are also featuring in, my lord, page 93.
No, they are not probably.
No, they are. They are.
They are. Then it's
Ravi Shankar Gupta.
cannot be a continuation. And one other thing, page 94 follows the format. The signature columns.
94 has to be correct.
94 has to be correct. Yes, the
93
signature columns contain the signatures, then resolution starts. And at page 93, you continue in the resolution portion also. Maybe if there's a shortage of papers, the same format paper, you may carry on in the same because.
But then, my lord, only thing that can happen is the names of those 9 persons are also included in 93 to give an impression or to, my lord, record all the names of all the persons who were present on that date. Because otherwise it
Maybe worse for you. It may be that these are the only people, 94, page 94 people are the only people who are present there. He was not.
No, if that is the case.
And 94 is an isolated
Then my argument that he accepted the resignation, that argument
goes.
Absolutely goes.
Absolutely gone. Yes. And that was one of the prints of our order.
Yes. Then that argument goes.
Because 94, if 93 is isolated from this, 94 is self-sufficient. There's an aura of self-sufficiency. Signatures are there, 9 persons sign, then the resolution. And it starts with number 1. So 93 then is the odd man out, sort of. No, we won't dispose. It will be risky to dispose the appeal like this.
No, my lord, since lordship has recorded, gives me, my lord, a day's time. I will seek instruction on this document. Whether, my lord, how this document is, my lord.
You come prepared on all the arguments made by Mr. Roy also because Rajendra Pradar Shaw has been shown to be a member of this House Homage Trust also.
Does not matter. Because
no, your consistent case is that you people are nobodies of that trust.
No, my case.
Their allegation is that House Homage Trust people are now coming in and trying to misappropriate the funds of West Bengal, House Homage West Bengal. But then that argument, your counter to that argument, one of the counters was that you people are not involved with House Homage Trust at all.
Always protecting the asset
Yes.
of House Homage Trust West Bengal.
But then Mr. Roy has been able to make out a story. Yes.
Trust it to say that my name is there.
Yes.
And my signature is there.
Yes, that storyline, his storyline becomes gains some validity, some currency. Because if you were a party there, and then his allegations regarding House Homage Trust people coming and swindling West Bengal from this, that may gain some validity, sort of. It becomes complicated.
But all this I fail to understand, then why
this matter is not part-hard, we hope.
Kindly makes it part-hard.
No, we won't definitely not make this matter part-hard.
My lord has invested.
We are in utter confusion.
Substantial time on this, my lord. Kindly makes it, whatever is the outcome, my lord, kindly makes it part-hard.
No question. During arguments, learned counsel for the appellant seeks some time to take further instructions in the matter. So accordingly, let the matter stand adjourned till next month, next year, whatever you ask for.
My lord, gives me, my lord.
Next week.
Next week. Only not, my lord, 24th, any other day, my lord, except 24th.
Next Monday.
Next, the 24th is next Monday. Then we'll keep it next Tuesday.
Tuesday, my lord,
25th. Till March 25, 2025.
I'm grateful.
Thank you.
I'll try and, my lord, clarify.
Yes, clarify.
I have to.
And brush up your Hindi also in the process. And Mr. Rai should also do that.
Only my interest to protect the trust property till the disposal.
That protection you won't get in this matter because this matter is only in respect of a notice. That protection you can get only from the city civil court.
Great.
Either this notice remains or it remains stayed.
Conduct would play an important role now.
Conduct would be no, but you won't be able to hold your elections only. You can give whatever. We won't advise you. কালকে একটা নোটিশ দিয়ে আবার ইলেকশন ফালতু করছি না না এটাতে সন্দেহ হচ্ছে হ্যাঁ যদি এটা হয় তাহলে তো এটা করতে আমার মনে হচ্ছিল এটা লাস্ট এটা সাজিয়েছে রং কিন্তু কোথায় প্রবলেমটা জানেন তারপর লাস্ট পিসটা কমপ্লিট হ্যাঁ তাহলে ফার্স্ট পেজে কয়েকটা সিগনেচার লাস্ট পেজে কয়েকটা সিগনেচার থাকবে সেটা না আলাদা যদি এটা হতো তাহলে এই সিগনেচার গুলো পরে শুনবে মিটিংটা হয়ে যাওয়ার পর শুরু থেকে যদি হয় সবকটা সিগনেচার পেছনে থাকবে সবকটা সিগনেচার আগে যদি সবকটা সিগনেচার আগে থাকে তাহলে এক ওটা তো ওই ছেড়ে দিন ওর মধ্যে ঢুকলে এখন অন্য মতন নেক্সট কল দেন দুপক্ষই জালি করছে না দুপক্ষই অনেস্ট What is the defect?
It is appearing in the list suddenly, so I have not identified the defect yet, my lord.
Identify. We are giving you 5 minutes password. Identify. Password for 5 minutes. এটা রিমুভ করে নিয়েছি আইডেন্টিফাই করুন কল অন দ্য এক্সপার্ট এটা আবার 5 মিনিট বাদে রাখবো
Hello. I'm paying for a week at January. My suffering.
Once it was dismissed for default, restored.
Yes.
No, we have restored the appeal. You must be prepared in the matter.
Short time.
5 minutes for you also. Suffering from what?
Sabnam Laskar is suffering for people. That's why we cannot come to court, man. That's why I'm paying.
Ashraf Ali, you are Mr. Ashraf Ali.
Ashraf Ali is a senior. He is also not present.
He is also suffering from fever.
Not
Hey,
present.
why are you?
I'm just Sabnam Laskar is the advocate record. He
Ashraf Ali, Mr. Ashraf Ali is the senior. He must argue. How does Sabnam Laskar matter? No, Mr. Ashraf Ali must be there. Call him.
He's not in seat, man.
Not in his seat.
Yes, man.
We'll pass it over for 10 minutes. If it does not come, we'll dismiss it for default. These old second appeals we won't keep pending. Running means there is no stay. They will be benefited if it takes time.
Due to pendency of the second.
That cannot be a reason for stopping the execution. They're not enjoying any stay. Then,
one day accommodation or
on the prayer of the appellant, the matter is adjourned for the day. No, only not today. Next. Section 5 আছে নিশ্চয় Yes, Mr. Podo, what is the delay? Appearing for the first time?
Yes, first time. No, second time before your lordship. Last occasion on
Copy was directed to be.
Yes, copy served my lord today. Unfortunately, my lord 40 days delay. My lord delay occurred.
No, you have soft copies.
Yes.
Where is the affidavit service? Oh, some learned advocate is appearing.
Mr.
Mr. Shonak Bhattacharya, he's a regular. Anyway, if he's not there, what can be done? Yeah. What is the delay?
This delay took place because of the fact, my lord.
Yes.
After disposal of the injunction application, my lord, we took out one application, 151 of the Code of Civil Procedure, praying for uh, modification of the ordering portion. My lord, what happened, my lord? Kindly come to the order itself. My lord, the learned judge, while my lord passing this order, disposing this application, my lord, he was inclined to restrain the defendant. My lord, kindly see.
You are the plaintiff.
I am the plaintiff. Though the application of the plaintiff as well as the defendant under Order 30 Rule 1 and 2.
Both filed the injunction.
Both preferred.
Acha.
Running page 4 of the judgment.
Yes.
In view of that middle portion of 2, 3, 4, 5, 6, 7, 8, 8 line from the bottom, in view of it.
8 line from the top, not the bottom.
From the top. In view
You are confusing the top and bottom. What is happening, Mr. Poddar? Too busy. So 8 lines from the top in view of that.
Without deciding the actual issue in controversy,
Yes.
for the sake of paramount interest of the business and its protection and presentation, the defendant officer prevented not to. My lord, not to is, my lord, unintentionally, my lord, it was incorporated. While the learned judge was intention was restraining.
Yes.
Defendants are prevented from interfering. So, prevented not to interfere with the business of Bharati Vastralaya. It becomes a double negative, my lord. For that reason, we pray for application. My lord, that was not, my lord, entertained, my lord. For that reason, it was delayed.
No. This means that clearly that it's preventing from interfering.
Yes.
Yes, you are right.
Otherwise, everything is in our.
Otherwise, you have no grievance against this order.
One issue, my lord. My lord, practically speaking, my lord, the dispute between the son and mother.
No, you are the son.
I am the son.
So you are directed to provide sari and wearing apparel for defense.
There was a business. My lord, namely Bharati Vastralaya.
So in a year, 12,000 worth of sari and wearing apparel is to be given to her. Give it to her.
No problem, my lord. What happened? This is it is Bharati Vastralaya. We two are the partners. My lord, we are drawing rupees 6,000 as per our agreement. Entered into not written.
You have got an injunction by this order. You have got an injunction in your favor.
There, but
Your appeal, why?
It is my mother. There was initially we started drawing rupees 2,000 per month from the business income. 2,000 per month drawings. Thereafter, at the end of the year,
no, we don't. What we don't understand is that this order has been passed in your favor. Why are you preferring an appeal?
In my favor.
So then, why have you preferred the appeal?
Instead of
condition 12,000 or 1,000 rupee per month. Sorry, and whatever this means.
I am not paying. It is from business.
Yes.
So business, it was agreed that 6,000 to be paid as a drawing. I also drawing 6,000 from the business. Earnings of the business. But learned code below, my lord, make it 12. My lord, our profit is 2,40,000, my lord. I provided, my lord, balance sheet.
12,000 rupee in a year, 1,000 rupee per month.
12,000 per month.
Please come to the order.
So per month, so equivalent. This is worth of 12,000 to be of saris and all, and 12,000 per month instead of 6,000. Well, my mother.
Show us that my mother we have heard too many times, so we can understand. You are litigating against your mother, my mother.
There was a suit.
For what, my mother, bro?
There was a.
Please don't use the expression my mother. You are in litigation with your mother. She's your partner in a business. It's a commercial relationship now. Please come to the point. Show us from the whatever deed that she is entitled only to 6,000. Show us that. Your mother, my mother, not immaterial now after the litigation.
It is a ST application, my lord.
Mr. Poddar, there is a deed of partnership. Show us from that. What is the profit sharing ratio?
Stay applicable.
We have reached the partnership deed itself. Page 56. Yeah. দেখি মাদার কত আর মাই সান কত
Paragraph 9 of the partnership deed,
Right.
page 4.
Yes.
9. The net profits of the partnership shall be divided between the partnership in equal shares.
9 page 4.
Page 4, paragraph 9 of the deed.
There are two partnership deeds.
At page 48.
48 yes.
At page 48.
Yes. Equal shares.
Yes, equal share and 12, paragraph 12.
Yes.
Partners are entitled to get a salary of rupees 2,000 per
What is salary?
Well, this was mutually agreed later on.
Yes.
6,000.
Where do we get that?
This was 2,000. Because
Where
it
do we
was-
get that it was later on agreed to
That
6,000?
was not written here. We mutually agreed, we enhanced it. It was said that per month, which may be increased or decreased in future, depending on the development of the business. So we make it, my lord, 6,000. I also drawing 6,000, my mother also drawing 6,000. So, my lord, our prayer was we are ready to provide 6,000 as we are,
What does the trial court get 12,000?
my lord, nowhere. And there was no basis of our suit because there was a earlier.
There was no basis of your suit.
No, earlier my plaintiff is not intended to file any suit because it is.
We'll record that, we'll dismiss the suit.
Well, there was a suit at the instance of my mother. That in that suit of my mother,
You're very possessive of your mother.
in that suit, my lord, there was an order of status quo.
Mother filed the suit first.
At the instance of my
Sister? Sister, obviously.
She is making,
Your sister is me too.
yes.
She has executed a power of attorney in favor of your sister. So now it becomes my sister.
So, my lord, it is 6,000 and 12,000. This difference is the. Or kindly, my lord, modified it. They all, my lord, the opposite party also filed execution proceeding for recovery of this amount. But my lord, I provided
The filer,
provided 6,000. She refused. I get it back from the post office.
obviously, you are directed to pay 12,000. You're
First, immediately after this order, about 1 year, one and 1.5 year, she accepted. But thereafter, recently, she is refusing.
no 12,000. What is the basis of this 12,000? Let us see that.
That is, there is.
But Mr. Poddar, be careful. If you don't point out, then he'll point out. Before he points out, you point out. What is the basis of this 12,000? There is no. Your suit is for what? You have asked for a declaration that.
So that the opposite party, defendant number 2, can't interfere in the business.
But she is an equal partner. She has every right to interfere.
Two, my
Oh.
sister, my mother.
Your prayer is that, not that.
1 and 2.
And in your temporary injunction, you ask for restraining. Oh, no. He's right. He's right.
People.
You're right. 2 from this.
He was a sleeping partner. So, my lord, when my lord, deed of partnership was my lord, this power of attorney was executed, she rushed to the shop room and
But you are taking advantage of your mother not being able to come. Therefore, she has.
That's not. It is after.
So, what is the basis of your challenge to the power of attorney? Your mother has a right to execute a power of attorney in favor of her, whoever.
So whatever what we agreed, we pay. We pay 6,000. We pay yearly once in 2 occasions, Poila Boishak and my lord, the Durga Puja, wearing apparel amounting to rupees 12,000. We have no problem.
This is the temporary injunction application on the basis of which the order is passed.
Yes.
This is page 28 is the prayer.
Yes.
Mr. Poddar, this is the injunction application. So you have asked for an injunction restraining defendant number 2 and men and agents from entering into business or disturbing.
My lord.
Why should you get that injunction? Because you are, she's the constituted attorney of your mother, and mother is an equal partner in the business. There's a power of attorney. She has a right now to interfere.
To grab everything. She asked me to get out.
But you are asking her to get out.
No.
Your injunction is that she will not interfere. She will not enter into the business, or she is restrained from disturbing you exclusively from running the business. You cannot do that. She is an equal partner. She has every right to interfere with your business.
She is not the partner. My mother
She is
was
the power of attorney holder of your partner.
mother of the partner.
Power of attorney holder of partner is equal right, has equal right.
My lord, a partner can't execute on her own volition to anyone, to execute power of attorney, and I am to accept him as a partner. It requires for admission of new partnership agreement. Without that,
You have a point there.
it's the partnership.
You have a point. You have a point there. But then you have got an injunction from the trial.
Only thing, my lord, dispute is, my lord, 12,000. I am ready to. I am giving to a 6,000.
Mr. Bhattacharya will we are allowing the section 5 application immediately. We are admitting the appeal. We are hearing the appeal. Now, you satisfy us about the 12,000.
Two things, my lord.
Just let us allow the. Upon hearing learned counsel for the parties, we find sufficient explanation for the delay in preferring the appeal. Accordingly, can 1 of 2023 is allowed, thereby condoning the delay in preferring FMAT 498 of 2022. Push up next para. Since questions of both fact and law are involved in the appeal, the appeal is admitted and will be heard on the grounds as taken in the memorandum of appeal. Push up next para. In view of the short conspectus of the appeal, formal preparation of paper books and records are dispensed with. Push up the appeal is taken up for hearing. Show us the basis of 12,000.
12,000, my lord.
You have not challenged the order. They have got an injunction that two cannot interfere.
Yes. Now, my lord, what happened?
Show us the basis of 12,000.
12.
Otherwise, we will allow the appeal. If you can show us a basis, we dismiss the appeal.
Yes. Lordship has seen their prayer. Prayer is that the plaintiff is entitled to carry business on the carry out the business freely without interference of the defendant number 1 and 2 and their main agents and associates under the name and style of Bharati. Milord, this is their declaration. Now, milord, they have not prayed, milord, for dissolution of partnership.
No, they haven't.
No. Now, milord, we have filed, milord, written statement along with a counterclaim where, milord, we have prayed for dissolution of partnership firm and accounts. Now, milord, as of today, we are totally unaware what is the, milord, share of profit in the business. What are they earning? Only, milord, by saying, milord, they are 240,000 is yearly income will not do.
You have not asked for accounts.
So, milord, in our, milord, partnership counterclaim, we have, milord, this is the copy, milord.
No, you also filed a temporary injunction application.
No.
Yes.
Temporary injunction application. Yes.
His yes is much more loud, much louder than
written statement and counterclaim.
You have asked for a counter injunction so that they may not disturb your.
They may not.
You have executed a power of attorney. You have entrusted your daughter. Mr. Poddar has a point there. No, anybody and everybody cannot be inducted. Then you have to reconstitute the partnership.
The age and her health
But
condition.
she's a partner. She cannot employ somebody else to do that. You could have asked for accounts.
That is my.
You have asked for injunction so that he may not disturb your running the business. You cannot run the business. You are admitting that. Then
Partner,
how can you get an injunction at all?
Now, milord, injunction, milord, what happened, milord? Injunction, ultimately, milord, due to, milord, the treatment cost of that lady.
Mr. Bhattacharya, we can treatment cost is something else. You have a maintenance right for that. That does not have anything to do with the partnership business. You file a suit for maintenance against your son.
That is there, milord. But, milord, kindly see, according to
12,000, we don't find any basis whatsoever. This is just autocratic on the part of the court. Totally arbitrary. How does he or she get the amount of 12,000? We can modify this order. Ask him to furnish accounts, audited accounts of the partnership quarterly.
Yes.
That we can do.
After, milord, injunction application will be heard.
Ad interim injunction was granted.
No. Finally, suit is
disposed
on the preemptory board, my lord, because of it is 22.
Milord, let them file accounts, milord.
They'll file accounts in the suit, and the peremptory hearing has not started.
Yes,
it is scheduled for preemptory hearing.
No, it has been fixed for PH, but since, milord, appeal is pending, they are, milord, praying for.
We'll dispose of the appeal right now.
My lord.
We'll modify this 12,000, Mr. Bhattacharya. We don't get any basis.
But some, milord, ad hoc, milord. Otherwise, milord, even the treatment cost is also not coming out, milord. That is also.
What treatment for what?
Milord, is. No. Key, she's unable.
Mental pressure due to son's conduct.
That is the, milord, primary thing.
No, Mr. Poddar, I mean,
handicap.
no, we can appreciate that, but Mr. Poddar, you must have some. You are willing to pay 6,000 for the time being. So you have to furnish some accounts to show audited accounts.
They are every year.
Can we record your submission that you are agreeable to put in 6,000 subject to the outcome of the suit? Then we'll modify the order. We'll ask you to pay 6,000 per month to her. One. Secondly, you will also furnish quarterly audited accounts. Quarterly. Every quarter. Quarterly means 3 months. Quarterly audited accounts during the pendency of the suit.
All concern if quarterly, if the accounts is audited, it will be.
Then unaudited accounts monthly. You have to furnish the entire or your accounts to the court will. Extracts of the entire accounts.
Unaudited per month.
I'm very happy. Unaudited per month.
I'm happy.
No.
My
Audited accounts quarterly, Mr.
WhatsApp, my lord, I am not able to.
Forget WhatsApp.
2,40,000
You will have to file
2,40,000.
quarterly accounts because there is no protection for the lady otherwise. And this will make 6,000. At the outset, learned counsel for the appellant, on instruction submits that there was no reasonable basis for the learned trial judge having directed the appellant to pay a monthly amount of rupees 12,000 to the defendant stroke opposite party number 1 as a partner. Push up. The brief facts of the case are that the plaintiff stroke appellant and the defendant stroke respondent number 1, being son and mother respectively, run a partnership business. Full stop. Next para. The grievance of the plaintiff stroke appellant is that defendant stroke respondent number 2, the sister of the appellant, was appointed as a constituted power of attorney by the respondent number 1 mother, without having any reconstitution of the partnership business. Full stop. The induction of a third party to the partnership, it is contended, is palpably illegal. Full stop. Next para. That apart, since the respondent number 1 is not in a position to conduct the business, the appellant has been doing so. Full stop. Due to the hindrances caused by the respondents, it is argued that the appellant is not being able to run the business smoothly. Full stop. Next para. As such, learned counsel submits that the injunction order restraining the defendant number 1 from restraining the respondents from disturbing the plaintiff stroke appellant running smoothly the partnership business was justified. However, the learned trial judge, by the impugned order, also directed the plaintiff stroke petitioner to pay rupees 12,000 per month to the defendant stroke opposite party number 1 as a partner of the business. Full stop. It is submitted that there was no basis for the same. Full stop. Next para. Learned counsel for the respondents, for both respondents, Mr. Yes. Respondent submits that since the respondent number 1 mother is not in a physical position due to her different handicaps and ailments, to actively participate in the partnership business, she appointed respondent number 2, her daughter as the power of attorney holder to represent her in the business. It is submitted that the respondents are totally in the dark as to the earnings of the business, since they have been restrained entry to the business by the appellant. Next para, we find from a bare perusal of the impugned order that there is no basis whatsoever for the direction on the appellant to pay rupees 12,000 per month to the respondent number 1. Next para. However, even on humanitarian grounds, since the respondent number 1 is suffering from different ailments and is the mother of the appellant, the appellant concedes to payment of rupees 6,000 per month to the respondent number 1. Next para. That apart, we also find that since it is an admitted position that the respondent number 1 is a partner of equal share with the appellant, the ends of justice would be subserved if the appellant is also directed to furnish before the learned trial judge quarterly audited accounts of the partnership business. Next para. Otherwise, there would be no protection for the rights of the respondent number 1 as a partner of the said business. Next para. Accordingly, FMAT 492 of 2022 is disposed of by modifying Pardon?
498.
Yeah, what did you say?
92.
Oh, sorry. 498 of 2022 is disposed of by modifying the impugned order to the effect that the portion of the said order whereby the plaintiff appellant has been directed to pay rupees 12,000 per month to the defendant stroke respondent number 1 is modified to the tune that the appellant stroke plaintiff, the plaintiff stroke appellant shall pay a monthly amount of rupees 6,000 per month to the respondent number 1 on an ad hoc basis, comma, subject to the outcome of the suit. Full stop. Next para, that apart, comma, the appellant shall also file before the learned trial judge, comma, with advance copy to the respondents, comma, audited quarterly accounts of the partnership business till disposal of the suit. Full stop. Next para, in view of the suit already being on the peremptory board, comma, it is expected that the learned trial judge shall make endeavor to dispose of the same as expeditiously as possible without granting any unnecessary adjournment to either side, comma, preferably by the end of September 2025. Can 2 of 2023 stands disposed of in the light of the aforesaid observations, no orders to cost.
Areas have to be cleared. Milord, from the date, Lordship is granting it from the date of the order. But just like Milord, our section 24 maintenance.
Yes, section. What is the date of the order?
22 to areas have to be cleared.
6,000 she accepted, but since last
Yes, from
4-5 months, she is refusing.
No.
Yes.
Only once they have paid only once 6,000.
If there is any areas, we will pay it.
Kindly.
যেখানে বললাম 6,000 কথাটা যেখানে ইউজ করেছি ওটা কন্ট্রোল ফাইন করে 600 পর such payment shall be made from the date of the impugned order, that is from the month of August 2022, push up the arrears in that regard till the month of February 2025 shall be cleared off by the appellant in 3 equal monthly installments, comma, the first of which shall be paid by March 31, 2025, and thereafter by the last day of each succeeding month. Full stop. The current payments in that regard shall also be made by the last day of each current month, comma, beginning from March 2025.
We will produce our bank account particulars, let them deposit directly into our bank account.
But she refused since last 3.
আচ্ছা ঠিক আছে ওইখানেই যেখানে বললাম যেটা such payments, comma, both arrears and current, comma, shall be made by online transfer by the appellant directly to the bank account of the respondent number 1. Push up the particulars of such bank account shall be furnished by March 21, 2025 by the respondent, comma, through her respondents, comma, through their learned advocate to the learned advocate for the appellant in this court. Next. Yes. What is the defect?
Judgment decree. The preliminary judgment decree has not filed with the certified copy. Only the first appellate order judgment has been.
This is a second appeal.
Yes.
No, but subsequently defect has been removed. It is
The second defect is removed. Malad. There is
all
a
right.
dispatch in
So
date.
what about that judgment and decree to be filed? Trial court. Why didn't you file so long? File it. We'll give you a fortnight's time to do that. The appellant shall file the certified copies of the judgment and decree of the trial court within a fortnight from date. Full stop. The department shall accordingly furnish a revised report in that regard. Which of next para, the matter shall be listed under the same heading next on April 16, 2025. Please do it immediately. The department পাঠিয়ে দেবেন. do it. A revised report will be given and it will be sent to us. 16th is the next date. একটা 500 ছিল না? না 500 বোধহয় ছিল না। Yes. Yes, Mr. Rokit, what is that?
My lord, plaintiff is the appellant before lordship.
What is can 1?
And one that has been disposed of.
Ah, sir, very good.
Restoration.
Very. Yes.
Now, my lord,
Since you are appearing, it must be judgment of affirmance. Yes.
Lord, this is a judgment of affirmance, and my
Yes.
lord, suit is for declaration and injunction.
You are the plaintiff.
I am the plaintiff appellant. Now, my lord, it appears declaratory suit has been filed. The note টা কোথায় গেল স্যার? ওটা নয়। Let's make it this come. কি কথা? দাদা তো নিশ্চিত করে। এখানেই আছে। এইটা পর্যন্ত But this is a suit for declaration and injunction. Declaration, my lord, to the effect that the defendant is the constructive trustee of the plaintiff.
This was a refugee rehabilitation land. Allotment was made to your father. You rightly say that he took as a constructive trustee, but that was not the sticking point. The point on which it was decided, Mr. Rokit, is apparently that family on record was used. Now, at that point of time, had you taken birth?
At that point of time?
Yes, you had not.
No, no.
So, what is your construction of family on record?
Because, my lord, I have, my lord, in view of the trustee, the matter.
But can it apply to posterity? I have a family today. When I take the property, Mr. Rokit, I am taking on behalf of my family. No doubt on that. But if someone is born in the family subsequently, does he or she automatically get an advantage of that?
No, the property inherited by, though I was born
later. But
the
entire family is the owner of the property.
Entire family, not only the.
He takes as a constructive trustee.
Exactly.
Therefore, the entire family, the right develops on the entire family and progeny also.
This is my humble submission. Can you look to this exhibit 2.1? Well, that has not been considered at all, whereby the
The court says Exhibit A pertain to family on record.
Can you look to the
What was Exhibit A?
exhibit A, my lord, and 2A,
2
2-1.
by 1. A and 2 by 1. Where are those?
Yes. My lord, this is, my lord, the,
Where do we find those exhibits?
yes,
We don't have copies.
yes, this is a copy.
This is 2-1 or A?
2-1. My lord, in bottom, my lord, it has been written 2 by 1. In
Yes,
suit
yes.
number is also given.
Rehabilitation other members of the family shall also be deemed to be covered by that. এটাই তো নিয়ম রিফিউজি রিহ্যাবিলিটেশন ল্যান্ডে এটাই নিয়ম একজন নেয় সবার দিয়ে হ্যাঁ না এটা তো একদম স্ট্যান্ডার্ড ওদের একটা বাঞ্চ আছে ফান্ড ফাইডুশিয়ারি ক্যারেক্টার এই যে অন রেকর্ডের উপর গেছি you are a son and who are the other members of the family at the point of allotment?
Followed allotment in favor of my father.
No, who are the other family members at that point?
The other brothers, other brother.
Your mother was alive?
At that, no, mother was not alive at that just now. Number it appears the father made a gift, deed of gift in favor of one of the son.
You challenge the deed also?
Deed.
You challenge the gift deed also?
No, that is not there. I have not challenged. But my lord, in view of the trust deed, if it is declared as trust deed, and my lord, it also appears.
But after 10 years, it's transferable. So he transferred. He must have transferred after 10 years.
Yes, after 10 years.
Then?
Out. But my lord, as it appears from Exhibit 2-1, my lord, whatever right I have obtained.
Difficulty, Mr. Rokit, is both the courts will have chosen one of the valid constructions. Why should the appeal court interfere? That is it. Because here it is stated two things. It is the allotment is made for the benefit of all the members of the family on record.
Yes.
At that point of time, whoever was the family member, they all of them take together. But with a rider that you can transfer this after 10 years. So after 10 years, if a right of transfer is given, it cannot be for all posterity. Because if I have a right to alienate after 10 years, suppose 10 years have passed. Now we are after 10 years. Now, if the allotment was for all posterity to come, then there won't be any right to alienate also. It would only be heritable like a trichotenancy.
That subject to Kaisa.
Yes, please correct us on that.
As soon as I
Take
bond,
birth, yes.
I bond, then my lord, the interest devolved upon us through my father.
Father was still alive. This is not Mitakshar.
No, father is, my lord, the
since you were born, your father must have been alive.
Yes. No.
Otherwise, you could not be born.
I am claiming through my father. Why I should be deprived? Only one of my brother, he has been executed a deed of gift by virtue of the trust deed. That is my humble submission. The court should have considered it.
There could not have been a question of your rehabilitation. You were not in the world of the living then. You had not taken birth even. When the allotment was made, you were not there. It was for rehabilitation of all the members of the family.
Yes.
But that cannot continue forever.
No, question was if the
only people who were refugees at that point of time, they were given the benefit.
No.
The entire family.
Question is undoubted that my right to property through my father is not questioned, because if a property is allotted to a refugee for settlement of his family, he being constructive trustee for the family have no right to return, no right to transfer the other member.
Right to transfer was also given
to any particular member of family, depriving others.
এই দেখুন প্রথমটা directed by order of government to save and displacement of those being allotted to colonies or squatters colonies which are being regularized. Clear intuition that beneficiaries of the allotment will be all the members of the family on record. Though the allotment order was issued in one of the families, effective of সবার প্রত্যেকে তাই তো other members were shown as comprising this. যারা যারা নাম কথা হচ্ছে অনেক জন্মালো প্রসপেক্টিভ রাইটস নয় না I think all the persons were shown as created comprising the family. And I legally now shall have to be so these are the few and for that the executor is the process. We're going to say I reported in the allotment list too. যারা রয়েছে তখন তো check.
The father of the parties, my lord, being the allottee, will be found in a fiduciary capacity.
This is not a
character
right of inheritance, Mr. Rokhi.
To the protect of interest.
Those people who were there at that point of time would be deemed to be your family. That language has been used repeatedly in this government order.
Yes.
That were shown as comprising the family. A common propositor among the persons whose names were recorded in the allotment register as comprising the family. Your name could not have been recorded. That is your government order. Had to be a family member at that point of time. Sorry, Mr. Rokit, we are not allowing.
And my lord, the allotment
Yes.
was made for rehabilitation of all members of the family.
Read the entire thing, all members.
All members of the family, including the allottee, and he held the allotment for the benefit of all the members.
It does not stop there. All the members
of the family on record.
Yes.
On record.
That at that point of time.
Yes.
The present second appeal has been preferred against a judgment of affirmance whereby both the courts below dismissed the plaintiff's suit for declaration of title and ancillary reliefs. So the next para, the plaintiff contends, the plaintiff/appellant contends that an allotment was made in respect of a refugee rehabilitation property in the name of the father of the plaintiff/appellant. It is contended that such allotments, by their very nature, are allotted to one of the members of the family in the capacity of constructive trustee, for the benefit of all the other members of the family. Full stop. Next para. It is submitted that although the plaintiff/appellant was not born at the time when the allotment was made, by virtue of being a son of his father, that is a member of the family of the allottee, comma, title to the property also devolved on the appellant. Full stop. It is contended that in while dismissing the suit, comma, both the courts below overlooked such component of the matter. Full stop. Next para. We find from a composite reading of the judgments and decrees of both the courts below that the courts concurrently found that the allotment, comma, although in the capacity of constructive trustee, comma, was made for the benefit of all the members of the family, তারপর italic say on record, full stop, since the appellant apostrophe s name was not in the records as he was not yet born at the time of the allotment, comma, it was held by the courts below that the appellant is not entitled to a right in the property. Full stop. Next para, learned counsel places reliance on a government order, Geo capital, bearing government order number 34992 stroke 17 hyphen rehab, Arta capital, rehab stroke 2 capital P hyphen 82 stroke 79, dated April 23, 1981, issued by the government of West Bengal through its deputy secretary. Full stop. Next para, as per the said government order, comma, as a measure of rehabilitation of displaced families, comma, homestead plots were being allotted to colonies or squatters, SQUATTOR, squatters in approved squatters colonies for being regularized with the clear intention that the beneficiaries of the allotment would be all the members of the family, তারপর double inverted মধ্যে on record, double inverted close, through the allotment order, though the allotment order was issued in the name of one of the family members as Korta or de facto head of the family. Full stop. Next para, it is also stated in the said circular that the conveyance deeds, comma, leasehold or freehold as may be approved from time to time, comma, shall have to be executed by all the persons who are shown as comprising of the family, comma, his legal heirs, comma, if any was dead, comma, if the actual allotment was not in favor of a common propositor, or if there was no common propositor among the person whose names were recorded in the allotment register as comprising the family. Full stop. In cases where deeds have already been executed and registered in the name of one member excluding the other members of the family, comma, the rehabilitation of the other members of the family shall also be deemed to be covered by the allotment, though it was made to one member of the family as Korta or de facto head of the family. Full stop. In such cases, comma, the government order further provides, comma, the allotment would be in the nature of a constructive trust for the other members of the family. Full stop. He would be found in a fiduciary character to protect the interest of the other members of the family, as he would be well aware of the fact that the allotment to him was made for the rehabilitation of all the members of the family, including the allottee, and he held the allotment for the benefit of all the members of the family, তারপর আবার double inverted on record. Full stop. Next para, the repeated use of the expression double inverted on record goes on to show that the allotment did not create a right of succession or inheritance in terms of personal laws. Full stop. What the government order and the policy of the government at that juncture intended was that all the refugee persons who were squatting on properties were entitled to such allotment. Full stop. For the purpose of convenience, comma, the allotment or deed was executed in favor of one of the family members who would hold on behalf of all the other persons who were his family members at that point of time. Full stop. Next para, the use of the expression within double inverted family who might have been the eldest brother or else as per composition of the family as recorded in the name of allotment of the plots, double inverted clause. In the opening paragraph of the government order goes on to show that not necessarily does the allottee, principal allottee have to be the father or the actual karta of the family, but he might as well be the elder brother or as per the composition of the recorded family, comma, any other person in the family. Full stop. Thus, comma, the concept of Hindu undivided family and in such context within double inverted karta is not applicable to an allotment under the refugee rehabilitation scheme. Full stop. Next para. Hence, comma, the construction which was given to the said government order and the policy of the government by both the courts below was one of the plausible interpretations which could be lent to the same. Full stop. Next para. Thus, comma, since it is well settled that the second appellate court shall not substitute its own views merely because another view was possible, and in the teeth of concurrent finding of both the courts below independently to the effect that the plaintiff stroke appellant not being a recorded family member at the juncture of allotment is not entitled to any share in the property, comma, cannot be interfered with in second appeal. Full stop. In such view of the matter, comma, we find that there is no substantial question of law involved in the appeal. Full stop. Accordingly, SAT 62 of 2020 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. No rest to cost. Can you please ask your learned junior to just make a photocopy of this and so that we can keep it on our record? Because we are a court of the record and just during the course of the day, please do it. Thank you. হতে পারতো যদি অন রেকর্ডটা না থাকতো তাহলে খুব ভালো কোশ্চেন অফ হতো। Yes.
But for the caveator.
Yes. Caveator.
Caveat করেছিলিস নাকি?
May it please the Lord's Lord.
Yes, Mr. Chakravarti, what is the matter? Second appeal, good. Affirmance.
Yes, Lord.
What is the matter about?
But I have prepared a list of dates for your Lordship, Lord, and a family tree so that it becomes convenient. Other side can copy the. Lord, suit for partition. I'll take your Lordship the list of dates. Suit for partition. I purchased from Rampodo Mondal in 2002. Now, kindly first take the family tree, this folded page. First take this folded page. Then I'll take your Lordship back to the list of date.
Yes.
This will be Lord of little importance for your Lordship. Lord, total land is 99 decimal. Bishambhar owned 50%. Ramhori owned 50%. Nobin, son of Bishambhar. Bamacharan, my predecessor, he owned 50%. Nobin had one son, one daughter, two children. Because Nobin died before promulgation of the Hindu Succession Act, Lord, Soirobi did not inherit anything. Lord, Nobin became the owner of the 50%. Lord, Bamacharan became the owner of 50%. Bamacharan adopted Rampodo. Now, Priyobala was the wife of Bamacharan. Bamacharan owned 50%, that is 49.5 decimals. Bamacharan sold.
Bamacharan died after 56.
Yes, Bamacharan date of death.
Not relevant.
No, before 56. Before 56. Before 56. Rampodo was adopted. Now, plenty purchased from Rampodo 32 decimal. And the defendant number 678 purchased the rest of the share of Lord Rampodo. Now, the defendant is, Lord, these are two separate. The issue is with regard to only suit property. Now, Gopinath, then Lakshman is the father of the defendant number 1 to 5. Now, this name would be a little important. Now, kindly take the list of date. What happened between the parties. একটা কপি দেন না প্রবালদার জন্য লিস্ট অফ ডেট এটা বানিয়েছি only one date lord would be there from their side lord I'll just tell that to your lordship lord kindly take 1st of October 1919 Rampodo Mondal was born into his biological father Indranaran Kapri and his wife.
Thank God he was not born to his adoptive father.
7th November 1919 Rampodo was adopted by Bamacharan and his wife
You
Priya.
need not repeat all these things because these are all there in the
No, the
chart.
dates are of importance because they are saying that
But it's a dispute, yes.
Bamacharan died in even prior to the birth of Rampodo.
Bamacharan died
In
back
1915.
1915.
1915. They are saying that in 1915, Bamacharan was brought to Calcutta from Midnapur for treatment and he died in Calcutta in 1915. They produced one death certificate. We produced a death certificate.
There was the question of his adopting Rampodo.
That is their story, Lord. That is
Rampodo
their
was
story.
born when?
1919. Our case is Bamacharan died in 1927. Rampodo all along throughout his life was accepted by the family. Well, the list of date will make things clear. Only one date, kindly take note. Mr. Mukherjee will tell that 21st November 1915. That's the only date from their side. 21st November 1915, date of Bamacharan.
1st November 1915.
1915, date of Bamacharan. Now kindly come back to the list of date.
They produced a death certificate also.
They produced a death certificate from Kolkata
Of
Corporation.
1915?
1915. Yes, no, that's a very. I will come back to that. That witness initially says he is from locality. Then it came out from the evidence that he is from Kolkata. He's a
Cannot
businessman of
reappreciate
Kolkata.
evidence. Very
I'm
little
not
so.
on that. Lord, the court has gone in a way. Lord, adoption which has taken place 100 years back. The family accepted. Kindly see the list of date once. Everything will be clear. Lord, kindly now come back to the list of date.
No, the entire case depends on the death of Bamacharan. Date of
Lord,
death of Bamacharan.
Rampodo had all along been known
Bamacharan
as
died after, then you would get a right. They wouldn't have any issue. Couldn't have any issue.
there are two death certificates. One issued by the local authority, produced by us. One issued by Kolkata Corporation, produced by them.
What is the locality?
But the district authority issued not. It is in Ghatal.
Ghatal.
In 1915, somebody will come from Ghatal to Kolkata for treatment. A villager.
Why not?
Extremely unbelievable, Lord.
1915 Ghatal would be worse than present Ghatal, and Kolkata would be better than present Kolkata.
That I cannot comment, Lord. That will be
1915 Kolkata was, there was a
But
huge difference between Ghatal and Kolkata.
But
unlike today, I mean, today it may be more equal.
Not that, Lord. It was very difficult.
But we
Lord, to
cannot
commute.
proceed on those conjectures in a second appeal.
Not on that. Lord, the family accepted him. Family accepted him.
Family birth certificate has
Last
been produced,
100
death
years.
certificate has been produced.
We
That
have
has been
also
believed
produced
by
a
both the courts below.
Now, why believed?
Why
I'll show
believed?
that. I'll show that. Lord, under what pretext the authority has believed, the court has believed
What
it.
pretext?
I'll show that to your lordship. Just one document. Kindly see the list of date once.
Yes.
26 December 9.
Substantial question of law is that Mr. Mukherjee is appearing. There may be something.
Of course, there has to be something. Lord.
There has to be
Appeal should
something in your
admitted.
case.
Appeal
Yes.
should
We are
be
trying to find that out.
Appeal should be admitted.
Otherwise, you shouldn't have been briefed in this matter.
Lord, absolutely. But there is something.
Something must be there.
Lord, 16th September 1930. Kindly come to the list of date once.
We are there. 6th
6th September 1930.
September. Yeah.
A Nirupan Nama was executed by Sourabi. Lord Sourabi is the daughter of Nobin, sister of
Herself did
Bamacharan.
not have anything, you said.
Sister of Bamacharan.
She had limited right.
She had her own property. She executed the Nirupan Nama, where Milord Rampodo petitioned in favor of Rampodo, where Lakshman Mondal, the father of the defendants, has signed as a witness. That was exhibited in the court below.
Achha.
In 1930, a deed was executed Nirupan Nama, whereby
1930 Nirupan Patra by Sourabi would not mean anything.
Lord,
If it was 1937, then even then Hindu widows' rights would come in. But before
of her own
1937,
property, of her own
Hindu
property,
women had nothing. The married
of her own property. She executed a Nirupan Nama of her own property to her nephew, where Lakshman, the father of the defendants, has signed as an attesting witness.
All right.
In that deed, I'll show that was exhibited. There it was written that since my brother has adopted Rampodo, I am giving my property to Rampodo, where Lakshman the father of the defendants has signed as an attested witness. The family accepted. The deposition of the DW1 says that all along Rampada in his school certificate, he was admitted as a son of Bamacharan. His voter card, Aadhaar card, ROR, the entire property was recorded in favor of Ramacharan, by Ramapado as 50% owner after the death of Bamacharan. And there was never thrown any challenge was thrown. So for
his school certificate is also there.
yes, it's exhibited. I'm giving you a lot
For school, what sort of certificate? School living certificate or what?
No.
School certificate means
Not the can you see this?
a certificate given by the school.
Yes. That from the record. No. Kindly see the doc.
This was exhibited. By whom?
Exhibited. Kindly see the document prior to that.
Who proved it?
Not the
School-
PW1.
Somebody from the school, no.
I have to check with PW4 ke chalo that too. Yes, the teacher came from the school.
That is very important.
Kindly see the just document prior to that, the voter card. Just have a look at it. The page one before that. Just one page before that.
Yes.
See Rampada, son of Bamacharan.
Where is Rampada? There are so many people.
Left hand side, top from top third column.
Achha, yes.
I has got that.
Yes, yes.
Now kindly take the exhibit
So
2.
one is school certificate, ROR, voter's ID card.
Yes.
And in Shourovi's Nirupan Patra, defendant's father Lakshman was a signatory.
See that
witness.
document once, exhibit 2.
We take it for the time being. See,
And see the death certificate once that was produced by us. This is the document.
But you also produced a death certificate
Yes.
from?
Yes, this is issued by Lord District Collectorate. Record keeping section. Kindly see this document. See this document, folded one.
Where is it?
This is the exhibit, Lord. Exhibit koto? This folded document. Kindly take this folded document. It's there in the bunch. Just before the Aadhaar card. This thing actually.
There's a folded document.
This one. Have there look at this.
Probably it was micro Xerox.
This was exhibited. Have a look at this. Kindly see the date of death. Kindly see the authority issuing it. Everything is matching. Police station, Daspur district, Midnapur. Serial number 64. Date of registration, 31st December 1927. Name of the person who reported the death, Bholanath Khorai, is also there.
Who is Bholanath Khorai?
In the plaint, we have made out a case that Choukidar, who reported the death, his name is also there. Then kindly see the deceased name, son of late Nobin Mondal, in the middle. Malaras kindly got that?
Yes, Nobin Mondal. Yes, Nobin Mondal.
The Xerox diya ache.
Yes, yes.
26 December 1927.
Date of registration is 31st of December 1927.
A date of death in the middle of the page. Date of death.
Yes, 26 December.
Yes, 1927. Place of death, kindly see, mark 8, column number 7, place of death.
And as opposed to the, so you produce Shourovi's Nirupan Patra signed by Lakshman, school certificate, ROR, voter's ID card, district collector's death certificate.
Yes.
And they produce only one
They produce only one death certificate and my birth certificate. And he admits in
your
the,
birth certificate.
yes, I mean the Rampada birth certificate.
Rampada's birth certificate is admitted.
It's admitted, no dispute is regard to that. Not even The
But
witness,
isn't that a reappreciation of evidence? The number of evidence
the court,
overwhelmingly more. Your number of evidence.
an adoption taken back 100 years back, they are questioning in their written statement.
How can the second appeal, if it is the first appeal, it would be a fantastic case for you.
Lord, kindly
There's so many documents against one.
the court has given dismissed the appeal on some perverse finding. I'll show that to you, Lord.
What is the perversity?
Court says, court disbelieves this deed, saying that, court disbelieves this deed, saying that, I'm just reading that portion for your Lordship kind consideration. Court says, it may be that, page 10, it may be that the deed of 1930 was created as a safeguard for the two widows, namely Priyobala and Souravidasi, to avoid the revision of property to Gopinath. Now, in 2014, you are saying a deed of 1930 was created with a motive that in future something will happen. These findings
Trial court finding.
The appeal court finding, trial court finding is also there. Absolutely adverse. Now I'll show one more thing.
When did they obtain this death certificate from Calcutta Municipal Corporation?
Lord, I don't have that Lord, that exhibit with me. I don't have that exhibit.
Is it discussed anywhere? Discussed anywhere in the?
Yes, I'll show that.
Achha.
Kindly have a look at page 13, 12, it starts.
Right.
And 13 of the trial court.
Will it take? Now my biological father has also attested in a deed where Rampada transferred the property, saying that I have been adopted by Bamacharan. That also been, and the CSROR, RSROR has been not looked into. And what they are saying is, their defense is Lakshman was uneducated, Rampada was in the family. They don't say that Rampada was not in the family. They say Rampada is the family. Rampada was entrusted to look into the ROR.
Yes.
So Rampada somehow managed his name in the ROR, but that they never challenged it. That's their defense.
It's ultimately evidence versus evidence. That is the difficulty, Mr.
So kindly come to page 13. See what the trial court says. Bamapada, which is contradicted by evidence of PW1 according to the plaint case. Bamacharan.
Where are you reading?
Page 13. Page 13. Page 13. According to the plaint case, Bamacharan Mundal died on
the contrary.
On the contrary, the defendant also filed an original death certificate of Bamacharan. Perhaps this was a certified copy was produced. Bamacharan, along with the attested copy of the death register, from which it reveals that date of death of Bamacharan Mundal was 21st November 2015. Not only that, Dr. Soumen Guchait have deposed as DW5, who was posted as Sub-Register Health Center, Kolkata Municipal Corporation, who had proved the extract of the copy of the original register. So his evidence was only whether the extract was from the register or not. Nothing has transpired from the cross-examination of DW5.
The defendants also exhibited the attested copy of death register.
Yes, we have produced the certified copy. They produced the register. Lord, kindly appreciates only one thing. I am claiming right from Rampada. I purchased in 2002.
No, they have produced the register itself, death register.
Yes.
And you have produced a certified copy.
Certified copy from the register.
Not a certified copy, certificate, death certificate.
Certificate of death.
Certificate is not a certified copy of the register.
Lord, they have produced
the original death register, a certified copy of the register.
They brought somebody from Kolkata Corporation with the register to show that the extract produced by them as Exhibit A is the same of the original register. My document has not been disbelieved that it is fake.
One of them has to be fake.
Now, kindly appreciates only one thing.
One of them has to be fake. Both the courts will have believed one of the documents.
A person who has been taken into adoption in 1919, who has all along been known as the son of Bamacharan. His name is recorded in school. He's in his service book. Everything is accepted, admitted by the witness. The witness, kindly have a look at the DW evidence. Kindly have a look at the evidence of the DW. He says that I cannot show, or I have no document to show that he was actually taken to Calcutta for treatment. Kindly have a look at this. And that the document they produced, the name was Bamapado, page 9 of the appeal court. I'll show that, not Bamacharan. They made out a case that Bamapado and Bamacharan is the same person. But kindly take the evidence of DW.
What document? Their death certificate is?
Yes, it records the name of Bamapado, not Bamacharan.
The death certificate.
Yes, they had produced death certificate. That is why I wanted the copy of that. Page 9. Page 9 of the trial court.
Oh.
Appeal court.
Yes. Plaintiffs have tried to make out
Yes.
a case that Bamacharan was only known as Bamacharan. No other.
Their case. That Bamacharan and Bamapado is the same.
But your documents, exhibited documents, show that Rampado's father's name was Bamapadu.
No. Bamacharan.
That is the finding in at page 13.
Lord, kindly come to internal page 9 of the appeal court order once. The last line.
Yes.
Last line.
Yes.
The said record.
Page 9 of appeal court.
Yes.
Oh, sorry.
I'm so sorry, Lord. I'm so sorry.
No, I'm so sorry.
No. Always my fault.
I saw the wrong thing.
Always my fault.
Yes.
Last line. The said entry.
Hmm.
Records of death of one Bamapada Mondal of Mastola Lane. Ward number so and the
Their death
residence.
certificate.
Their death certificate.
No. Your document also says that your father is the Bamapada. That is the finding of at page 13. That about just the middle, it will be pertinent to mention that plaintiffs had tried to make out a case that Bamacharan was only Bamacharan. He had no other.
Yes, Bamacharan.
Apart from exhibited documents filed by the plaintiffs, it appears
My
that
lord is
father's
reading
name of
page 9.
page 13 of trial court.
Trial court. Very well. Yes, my lord is reading, Lord.
Just beside that stamp of the civil judge senior division.
Yes.
It will be pertinent
to mention that
is
plaintiffs had
sentence?
tried to make out a case that Bamacharan was only known as Bamacharan and he had no other name. But from the exhibited document filed by the plaintiff, it appears that father name of Rampado is mentioned as Bamapado. Lord, perhaps, Lord, that is incorrect. The exhibited documents that we have filed.
These are the exhibited documents. You just check up whether your.
The death certificate is Bamacharan. Amader exhibited. Lord, may I take back my copy?
Which is your copy?
The original one. Lord, the list of exhibits, kindly see the first page. My lord will get that.
Yes.
Which document probably the name could be there. Kindly take the first page. First is my lord, record of Mouja. This first page of the
record of Mouja is different.
Yes. So
Your father's name has been shown as Bamacharan. Where? Trial court records that in your records, your father's name has been shown as Bamacharan. That could only be either your school certificate.
Yes, only that. Kindly see those documents.
Or voter's ID card also.
Voter ID card, my lord will find that it is Bamacharan.
Bamacharan. Check up your school certificate.
Bamacharan. In the deeds, my lord, I am. देखें ना एक बार भूल बोलिस ना his death certificate says Bamacharan, which we produced. My lord have seen that Bamacharan in the death certificate that we
your
produced.
death certificate says Bamacharan.
The defense case was Bamacharan and Bama was the same. They made that case so that they can produce the death certificate.
But nothing in support of that. The two persons are the same.
But I don't find from the judgment, Lord. Document গুলো দেখো Question is, you are questioning an adoption taken 100 years back. That gentleman's service book. Kindly see his case in the written statement.
What contemporaneous document did you produce?
The witness admits in the written statement, they admitted that ROR birth certificate, his not birth certificate, his school certificate, his service book, he was the secretary of the union. Everywhere it is written as Bamacharan, and he always referred himself as the son of Bamacharan. Yes, that's the only thing. Rampada never appeared. That is their case. That's the only reason. Court disbelieved everything.
Why didn't you appear in the doc?
Maybe Rampada did
the
not
best
agree. He was one of the best witnesses, but maybe Rampada did not agree after selling the property. But never any of the deeds were questioned.
You were
purchased from Rampada. Lord, Mr. Mukherjee's client has never challenged any of the deeds. Rampada has sold to many. Not only that, kindly sees these documents, the certificates. The trial court says in my now kindly sees the Nirupan Nama once. Exhibit 2. Exhibit 2 records Bamacharan, 1930 document. রামপদ ডোমে বাবার নাম নেই এখানে। Not kindly once take not page 6 of the appeal court order. Once.
Yes.
Kindly see at the top. Priyobala and Saurabhi both were affectionate towards Rampodo. Priyobala could have mentioned the name of Bamacharan as the father name of Rampodo out of love and affection towards him. Instead, the name of Indranaran Kapri. The said identity was carried throughout the career of life of Rampodo. Though Bamacharan and Bamapada Mundal was never the father of Rampodo in any manner whatsoever, in the gift deed of 1930 of Saurabhi, who was an illiterate and rustic lady, Rampodo was stated as the adopted son of Bamacharan, but wording have been used to scribe loosely. Their defense is in 1930, it was loosely drafted. None of our document is Rampodo.
The present second appeal will be heard on the following substantial questions of law. 1. Whether the learned courts below substantially erred in law in disbelieving the death certificate of Bamacharan, the predecessor in interest of Rampodo, the alleged predecessor in interest of Rampodo, the vendor of the plaintiffs, stroke appellants, কি বললাম আর বলুন
Because the learned courts below substantially erred in law in disbelieving the death certificate of Bamacharan.
Which was produced by the plaintiff stroke appellant in favor of a contrary death certificate produced by the defendant in the name of one Bamapodo, despite no substantive proof being furnished as to the identity between Bamapodo and Bamacharan. Next, Roman 2. Whether the learned courts below acted in a perverse manner in disbelieving the overwhelming documentary evidence, including certain contemporaneous documents, adduced in evidence by the plaintiff stroke appellant in support of the proposition that Rampodo, the vendor of the plaintiff stroke appellants, was the adopted son of Bamacharan, in the absence of any cogent rebuttal to the said documents. Roman 3. Whether the learned courts below committed a perversity by relying on a purported death certificate produced by the defendant stroke respondent, furnished by the Calcutta Municipal Corporation, by giving the same priority over the death certificate produced by the plaintiff issued by the concerned district collectorate of the place of residence of the deceased Bamacharan, in the absence of any corroborative evidence to justify as to why Bamacharan visited Calcutta at the time of his demise. Next para. Any application?
I'll direct the parties to maintain status quo.
But I appear for all the respondents, the notice of appeal may be dispensed with.
All the respondents?
All the respondents.
শিওর তো
Oh,
6 7 8 ও
তিনবার জিজ্ঞেস করেছি আমি।
না 1 to 5 হতে পারে 6 7 8 কি করে হয় yes 1 to 5 6
1 to
7
6,
8
7, 8.
they are subsequent purchasers from Ramapodo how can they appear
In view of a strong prima facie case having been made out and the second appeal having been admitted, comma, we find that a strong prima facie case for grant of injunction has been made out by the plaintiff's appellants. Full stop. Accordingly, the respondents are restrained by an order of injunction from
page 6 minutes
selling, transferring, alienating and or parting, selling, comma, transferring, comma, alienating and stroke or parting with possession in respect of the suit property in favor of third party till disposal of Can 1 of 2023. Full stop. In view of appearance of the respondent numbers 1 to 5 through caveat, comma, service of notice, service of copies of the application is dispensed with on the said respondents. Full stop. The petitioners shall serve copies of the application on respondents to opposite party number 6, 7, and 8, indicating that the application shall be listed before the appropriate learned single judge having determination at the relevant juncture, comma, when an affidavit of service to that effect shall be filed by the appellants. Full stop. Next para. Liberty to the parties to mention the application for hearing before the appropriate learned single judge after 2 weeks.
But may I just pray for injunction equally upon the appellant because they are claiming partition through a deed. But the first paragraph they say that they have claimed purchase from Ramapodo.
yes
Therefore, on the strength of that deed, if they sell the property, that will also create.
So, there is no application by you.
But your lordship can
Status quo, but there is no averment even. Sometimes is granted, there is nothing on record to show that. And at any point of time, did you enjoy any injunction in the court below?
But I won in both the courts below, Lord.
Yes, but during pendency of the suit, during pendency of the appeal, did you get any injunction? Did you ask for any injunction?
But I did not. But
then you can make an application.
I now apprehend on the strength of their the purchase date.
Yes, but you have to put that on paper. You have to put that on paper, Mr. Mukherjee. There is no averment, no application before us.
That I understand, but
how can you on the basis of conjecture, how can you do that?
but I prayed Milord that I
feel
am
very wrong.
Because it is a suit for partition, that was the reason why I was asking for.
No, this is a suit for partition.
suit for partition
Yes.
I purchased from Ramapodo I became co-share that's why I made everybody who purchased from Ramapodo
Sell the property, that will create third party interest and
you will not be creating third party interest.
I have been restrained. They are claiming on the basis of the purchase deed of Ramapodo. The learned judges said that the Ramapodo was never the adopted son, therefore he did not inherit and therefore he could not have sold.
Not at the, I will direct you to file opposition also, not at this stage, because there is nothing on record. Article and add coding affidavits shall be exchanged in the meantime. Not at this stage.
Lordship,